Hello.
Press-
Listen aloud.
Must have played.
Listen aloud.
Beautiful.
Listen aloud. Listen dismiss. Yes.
For admission, my lord, I already mentioned, but it's not listed today. So on Monday, my lord, for admission of the MSc.
Admission. Code number 8. Continue.
May I please, will
Yes.
my lord, item number, my lord, 28, my lord. Here in this case, my lord, MS Rajbarbhaiya was, my lord, engaged. He was supposed to do the case. He is, my lord,
28.
28, he is not keeping oil, my lord. My lord,
Okay.
may I pray, my lord, just pass over for the day, my lord.
On the prayer being made by Mr.
Hey, Manna.
Learned Counsel appearing on behalf of Mr. M. Raj Borbania, Learned Counsel for the matter stands over for the day.
Pass over for the day, my lord.
May I please,
Pass over for the day. Oblige.
may I please, your lordship? I beg to mention item number 16, lordship. It is wrongly listed before this honorable court, lordship. It is also listed before the court number 8, lordship, as a part third matter.
This matter has not been listed.
Lord.
Yes.
May I please, your lordship? In item number 50, today we have filed additional affidavit.
Item number
50.
50.
50.
Yes.
Your lordship, today we have filed an additional affidavit to bring one document before your lordship. So kindly may I call for that.
May I please, lordship, I beg to mention for listing one civil division petition, IO, lordship. In order,
Code number 8.
May I please, your lordship? Lordship, item number 55 of supplementary list may be adjourned for the day or fixed, may be fixed on next Monday or Tuesday.
55.
55
Okay.
may be adjourned or fixed on next Monday or
You are for?
because of personal difficulties of
You are for?
Pick.
You are appearing for?
petitioner
Okay. Your good name?
A.S. Chaudhary.
Sir A. Chaudhary, Learned Counsel. Appearing on behalf of
Petitioner. Oh, P.P. Das.
PP does, Learned conducting of court of petitioner. You inform the other side with consent of the other side. As for the matter after
On next Monday or Tuesday.
May I please, your lordship, I beg to mention one CRPIO for listing for withdrawal, lordship. Can it be tomorrow?
when?
Tomorrow, lordship.
These appeals are analogous appeals. We allowed to. These are arisen out of garnishee orders passed by the execution. The execution proceedings have been disposed of.
The decree has been satisfied, madam.
Decree has been
We have
satisfied.
received the decretal amount, so nothing remains in this appeal.
Third, take some Learned Counsel for the data.
Yes. Only one rest.
The part that this method as the degree as this take garbage that is equity. Better than run. Then all the matters.
All the four matters. All the four appeals.
Because four are connected, the execution can cases are
Deeply applied.
May I please, your lordship? Lordship, the instance CRPI has been filed under Article 227 of the Constitution of India, your lordship, for set aside and was the order, impugned order dated 23/4/2025, passed by the Civil Judge Junior Division number 1 of Nalbari in title suit number 106 of 2024, Your Lordship. If Your Lordship will find the impound order at page 18, Your Lordship. Your Lordship, the plaintiff filed an application before the Learned Trial Court under orders 16 rule 1 and 6 for summoning the sub-register of Mukalmua to produce the original cell deed, which has been rejected by the trial court, Your Lordship. Lordship, got it? The impound order at page 18. In this order, Your Lordship, while Yes.
It was executed, sorry, exhibited,
Yes, Lordship, Lordship. The certified true copy has been exhibited, but original has not been exhibited. Therefore, this petition has been made before this trial.
why the trial court has rejected the petition?
Lordship,
Why the trial court has rejected the petition?
because Your Lordship, if Your Lordship will find at page 21, Your Lordship, trial court has been given the reason because evidence that matter has been fixed for argument and evidence of both the side has been already closed. Therefore, our petition has been rejected. As per order of this honorable
Why
court,
you have not filed the petition earlier for the trial court at the time I can the petitioner?
petition has been filed on 10th December 2024. Yeah. Lordship will find at page 13 below down.
Whether you have mentioned in your claim that the original copy is not available.
No, Lordship. No, Lordship. That has been not mentioned in the petition. Why they have not exhibited the original document. That has been not mentioned in the petition here. Even though not claimed also, they have not mentioned about that.
Then
They have not possession or they have misplaced the original cell data. Therefore, they have apprehension. They have already exhibited the certified true copy of the cell date. If they will not prove before the trial court that they have apprehension that order may be go to against the petitioner, Your Lordship. That's why they have filed this petition, initial petition for summoning the sub-register of Mukalmua to produce the original from their record.
sir,
Yes, I Akan.
Colonel, already. In fact, 106/2014. The record learning from this sort of that the petition slightly has indicated I should take that wherein he has executed self clearing number 40 of 19, that is 47/99, executed artifact of self clearing, that is serial number T11, but he could not forward the original cell date as the volume of the cell date number 243 of 1993. But volume of the state cell date number 243 of 1993 is referred for this report for end of class and as the file one petition for one petition number 1981 of 24 but the learned trial court by the order dated to the order rejected the petition has rejected the on the ground that the is pending but on the ground that evidence
Close.
the defendant side has already been proved on 26/11/2024 and the date is fixed for argument and the petitioner the plaintiff has failed to mention the region which prevented him from filing the petition number 1981 of 2024 prior to closing of the hearing. And also on the ground that in the amended claim the petitioner has mentioned about the original salary number 43 of 1993. Which were not in his position. Second, learned pardon subject allowed to exhibit the uh, original salary original salary by copying the volume from the sub-register. Copy from the sub-register the
No,
petitioner will will not be able to allow the having heard the topic after converted conflict protocol. It appears that evidence of the defendant side has already been put and the matter has been for argument. Your argument was hard.
Yes, Lordship.
Argument hard.
No, Lordship.
It was listed on 14/5/2025.
It-
What happened on that day?
It was last posted on 15/7/2025, but last the present date has been not updated in online, so I have not aware of that date.
It appears that the certificate copy of the separate number 12 has already been exhibited by the petitioner before the learned trial. So the evidence of the defendant side has already been closed and the matter has listed for argument. Mr. Akan learned would have some said the argument has not yet been heard by the learned trial court. when considering both of the effect for this court is inclined to allow the chief order delivered for at trial court step all for the volume book of the stated number 43 of 1993 the copy published there and thereafter proceed to air the matter in accordance with the
Also oblige, Your Worship.
May I please, Lordship? Lordship, delay may not at first, my lord. Yet delay may not become not condoned, my lord.
whether topic was served.
Service, my lord, complete on respond number 1. He is necessary party, claimant, my lord. And earlier in tribunal, my lord, respond number 2 and 3 not appeared, my lord.
Notice is yet to be served upon respondent number
We have served 2-3 times, my lord, on respond number 2-3, my lord. Actually, my lord, this is not the insurance policy for MSC appeal, my lord. This is the damage of only soaps, my lord. 3 to 6 soaps, my lord. And
we are not married the merit of the case.
there is no third party risk, my lord, in this matter, my lord. Insurance policy is not covered, my lord. Damages may be claimed on property law, my insurance, my lord.
You have to take first step upon respondent number 2 and 3.
Okay, my lord.
Art means L sort of product product. None appears for the respondent number 1. Though one column number is 5 on it. Yeah. Office note dated 4/8/2025 indicates that the counsel for the applicant has not taken steps of respondent number 20. Accordingly, it provided that learned counsel for the applicant shall take prior step upon respondent number 20 by resort to area itself. Based the matter after for it. Since the service has not yet been completed, the matter could not be deferred to the mediation. So the same state under the column for reference the special time, right? For the
Oblige, my lord.
May I please refer your lordship? Lordship, this matter has been referred for mediation. We have no objection in this regard, lordship.
You have no objection.
No.
Yes, Mr. Sharma.
So we may try. But we have filed a cross objection also in this matter because there is a factor of contributory negligence. And the tribunal first and the entire liability upon us.
If Sate plea is taken, whether that can be adjudicated,
Because the awarded amount is not very high. That is,
pardon?
the awarded amount is not very high, lordship. Only 4 lakhs,
60,000.
53,000.
But is there any chance of settlement?
I leave upon your lordship.
Pardon means
Devashree Chakraborty.
they heard it from level and for response. It is submitted at the bar that the matter may be referred to the High Court magistrate, and as the thing listed under the column taking the referred by that the matter is referred to the court. The parties are directed to appear before the ideas or of when others said that
Dito tako. Dito tako. Did. It is not.
18th of August,
Obliged.
Obliged, lordship.
but your name is not there in the cause list. You are appearing on behalf of
Mr. S.C. Vishwas. Obliged, lordship.
May I please, lordship? In this case, lordship, delay was not condoned. There is a 24 days delay, lordship.
Lord, matter may refer to the mediation center, my lord. We have no objection.
Yes. By conducting that, I
is yet to be admitted.
Yet to be.
yet to be admitted, lordship. Or lordship may send refer the matter to a mediation, lord.
First, let us conduct the delay and admit the matter.
Yes, lord.
Delay of how many days?
24 days, lordship only.
Permit for applicant and services.
F. Hassan.
F.A. Hassan learned from the product. The interlocutory application record to the day of all this. In filing connected MSC appeal.
Yes, lord.
Judgment. And award dated
Judgment on 21/11/19.
2019, also the learned
Additional district and session judge SP.
FT for Uday in or I. Normal learned concept for the
Appeal
applicant submitted. What is the ground?
ground lordship 20. That lordship that it was the first lordship on 12/12/2019 addressed to branch manager petitioner company lordship, Hodai lordship. Thereafter it is recommended to the lordship GRO lordship. So there is a delay of 24 days lordship. There in the internal communication lordship.
That due to internet communication made with the appellant and its higher official, the appeal could not be filed in time. The same has been explained in paragraph number.
In lordship paragraph 7, there is a lordship COVID period also there. Lordship.
Paragraph number
7, 6 and 7.
and further inform that at the relevant time, COVID-19 pandemic was prevalent and there was nationwide lockdown, so which appeal could not be filed in time. nothing intentional, rather it is circum. Therefore, nothing. The other concepts of that is no object.
No objection, Mark. If they delay the counter, my lord, we have no objection.
Rather taking the part is also related that for the delay. It's 40 the delay has up and according to this term I give up the order for I will process to register the appeal and this same court has
You know,
let the appeal be registered.
Listed
Thereafter,
for admission column.
for admission.
Appeal will be listed for admission column. Date will be-
register
Appeal is on quantum lordship. Later may be sent to conciliation lordship. Later has discussion.
further cases with the current counsel. And third,
N Borwa,
and fourth, current
respondent 1 and 2. Respondent 1 and 2.
any objection in referring the method?
No, my lord.
No. Method is listed under the part. Then the letter may be referred to the method. And the dispute is only in respect of quantum of which according to the referred to the what the and the party appear part appear before the package of the effort on package for certified court and the
Hello, Raj.
Ago,
Like is your lordship.
yes,
I will enter appearance for respondent number 1, lordship.
one.
Yes, lordship.
So delay is
Lordship.
yet to be confirmed.
15 days,
We per se have no any objection towards the delay, lordship. And if lordship.
How the delay is explained?
it took time for approval. That's why. It took time for approval from
Approval.
the
Approval from
company and your general manager.
hardness. Your name,
P. Sharma. I, Lordship, I appear on behalf of S.K. Goswami.
uh, of the estate. And third,
NZ Chaudhary.
certain the certificate application. Five of them is preferred by the applicant to bill against the judgment and awarded with one caused by the certain member to the extent that certain conflict the applicant that not by time has that some delay has occurred in obtaining approval from the higher authority, and that the delay is not intent rather than therefore it is not the learned party delay. Rather taking the sum the part not considered the expenses of the delay. Put it the appeal. Terms of this IA stands at disposal, and in view of the order basket, will proceed to the target and take the matter before the court as well.
Lordship, may I, Lordship? Actually, we are also ready if the matter is referred for mediation, Lordship.
But the appeal is yet to be
Yes, Lordship, that is, so let it be numbered.
will refer it to
Of the Lordship. Sure.
May I please your lordship? Your lordship, though the appeal has been admitted, but the stay application is still pending. My prayer is that your lordship may direct the insurance company to deposit 50%.
when the appeal was admitted.
On the last date,
The last date, Lordship.
it is 25/7.
25/7.
25/7.
Subject to, let's say, furnishing indemnity bond, he can be, that amount can be released on 50%.
Why?
Lordship, this, here the challenges as regard the dishonor of the check.
As regard
Check was dishonored. The matter has to be heard in the meantime because.
Your lordship, I lost my son in this particular accident. I am living in very hardship. So your lordship may be pleased to grant the stay subject to deposit of 50%.
no, that's all right. Commits that you have to furnish one.
I'm ready to furnish a bond.
You are ready. Or there are some. So whether it is a application or the listed along with the appeal.
Yes,
Lordship.
That's
yes.
why a order was passed.
The other party was.
Your lordship, on last
Under other
occasion,
party.
your lordship has admitted the appeal.
Then why this was not read?
Oh, it was
Just to be hard on the next day.
next date. It was to be heard on the next day. So I have mentioned it. I have brought this matter by order.
This certificated application under order 5 of the Code of Civil Procedure Department. For staying operation judgment and award dated 30/7/2024 on by third and third. On the Gupta Bhai Garden applicant that the connected appeal has comparatively admitted by this court. Right, order dated
Order date Lordship 25/7.
25/7.
35/7. Record as of- Then then there is a record for staying operation and the award that is to till disposal of the MSC appeal. And the applicant will be able to both the 50% awarded amount for the award. And the further subject consequently allowed to be withdrawn by the opposite party hearing, subject to parties that may be won. Also, permit to the opposite party subjects that response ready to parties that may be won, and they allow to withdraw the amount to be deposited that for taking to the sub party the party for this related to the judgment and order ever dated caused by the garden family. Or accident with level of or type 5 of the state subject however of 50%. 50% awarded of on such deposit made. So it may be allowed to be done by the respondent opposite party on parts indemnity bond. This is successful.
Highly obliged, Your Lordship.
Hey, then borrowing from the
4 weeks.
4 weeks. Average.
Obliged, Your Lordship.
My lord, this matter may be preferred for a mediation, my lord.
My lord, kindly see the last orders, my lord.
My lord, we are
Uh,
ready to pay entire amount, my lord.
Last
That time, my
time,
lord.
last time they have submitted that the check has been disbursed and it is coming from Kolkata.
is it deposited before the rate?
Not
Yes, my lord.
Yes, my lord.
When?
My lord, we are going to deposit the entire amount, my lord. That's why, my lord, in mediation, my lord, we prefer for mediation, my lord.
Carry out the order. They deposit before the rest of this court.
Okay, my lord.
When?
My lord, at least 4 weeks time may be needed, my lord.
No.
For entire amount, my lord.
Already several weeks have been granted to you. Even
Well, we
they
have
will not
already
start-
discussed with the
Sorry,
company, my lord. That's why, my lord.
you deposit the amount before the rest of this court.
Only 50%, my lord.
As ordered earlier.
Yes.
Hard, sir.
M. Ali.
Internet applicant and also hard for the party. The current counsel for the applicant has pointed out that despite specific direction of this court, the respondent company has not audited the 50% amount, 50% amount for the rest of this court. Then it appears that by order dated 4/12, this court was pledged to direct from the opposite party to deposit 50% of the awarded amount before the rest of this court. But the same, have you started execution process?
Not yet.
Not-
This is because of pendency of this appeal, my lord. And the order was that subject to payment of 50%, award is stayed. And that 50%
So
not
they
yet.
have not deposited the amount you start execution.
Not what I am submitting, my lord. Since there is an order of this court, my lord, they have violated
They
the
have
order.
not complying with the order.
Lord. They have violated the court's order. So, my lord, this appeal, my lord, deserves to be liable to be dismissed, my lord.
Why we are going to deposit all?
Because, my lord,
amount.
subject to payment of 50%, my lord, the condonation delay was condoned. And this is pending since 2022. And they are repeatedly, my lord, only, my lord, assurance, except assurance, nothing is doing, my lord. Last occasion also, they said,
Therefore, the court's opted for you is to start execution proceeding again.
Lord, Lordship may direct within a week, my lord, they
No, my, within a week,
deposit
not
before the
possible, my lord.
registry.
So checks comes from the head office, my lord.
It was coming
From
since
where?
2022.
It, my lord, Calcutta or I think Bangalore, my lord. Kolkata, my lord.
Then have you gone through the record? No.
Yes, my lord.
So you
It is pay and recovery, my lord.
Last order was 25/6.
So on that day, another council entered appearance and tried for granting 2 weeks time. We have granted 2 weeks. And today you appear and you are praying for another 2 weeks. So this
My lord,
way you are delaying the.
this is our senior's file, my lord, briefly.
Those
That's why,
who
my
is
lord.
your-
SS Sharma, Mr. SS Sharma,
Pardon?
senior. SS Sharma, Mr. SS Sharma, senior counsel. my
You
lord.
let him remain present in the court. Well,
At true lordship.
My,
After some.
bless me. না এখন ওয়ারে বেশি কৰিব লাগে।
No problem.
My lord, Mr. SS Sharma is unable to attend the court, my lord. Only VC is possible, my lord.
okay.
Otherwise, in
At 2 p.m.
tomorrow, my lord, tomorrow,
No. Today at 2 p.m.
it is not possible because, my lord, he is 80 plus, my lord, and bedridden. That's why, my lord.
Dismiss your appeal.
Oh, bless me. My lord, in this case, there has been a delay of 133 days. Service is not completed. We will take steps upon the respondent number 3, 4, and 5, my lord. 1, 2, and 6 service is complete.
One, two, and
6.
one. Oh, have you gone to the office report? Office note.
My lord.
Have you gone to the office note?
Yes.
It stated that respondent notice could not be served upon respondent number 6.
It's, Ton has received.
Or Rohit had not open. It is 485. It's one served. And in respect of respondent number 3 and 5, this return answer to the report. That they could not be present in the address part. Accordingly, it is provided that the third and complete for the applicant obtain necessary information with respect to the address of the respondent number 3, 4, and 5 and the take price system. By registered to with JD and also in the process, they will come there, it comes out for
Marshal.
Not please, your lordship. Lord, file this IA. Well, we have to file objection to this, Miller. This come for the first time, Miller. There's an IA for Miller stopping the Baki proceeding, Miller. I pay for time to file objection to this, Miller. I'm for the insurance company, Miller. We gave him. For pain recovery, Miller, and they have not challenged it, Miller, separate, Miller. And they will in here, Miller, appeal file, Miller, by Miller, they have Miller now Miller filed this application. Whether this is maintainable, that's another issue, Miller. They have not filed a separate appeal, Miller, against the pain recovery order. And here, Miller, they're asking for stay by filing an IA, Miller. That's another issue.
no appeal has been
No appeal is in filed, Miller, by the owner, Miller. He has filed an IA in the appeal filed by the claimant, Miller.
they have filed one appeal perhaps. MSc
No, this appeal is Millard by Millard one.
I filed the.
Yes, madam.
I filed the appeal and for enhancement.
Enhancement, like, it's a claimant's appeal, madam.
There was a pay and recovery for the issue of driving license only. Driving license, it was genuine lordship. So the thoroughly it was found that there is no entry, but manually it was proved that it is genuine lordship. So there should not be pay and recovery order, and that should be revoked. And my claim is.
My learned friend is filed an appeal, Millard says
Yes.
now he's supporting Millard. I don't understand that. My learned friend is filed an appeal for enhancement.
Yes,
Now
sir.
he is saying Millard, he's saying against pain recovery, Millard. I find Millard, I don't know. I'll file my objection to this, Millard.
Let
They have not filed an
to
appeal.
file objection, my lord. Let me attend.
Here on.
Opposite party number? You are for opposite party.
Millard, I am for the opposite of Millard Insurance Company, Millard, respondent number, Millard. One, Millard, in the appeal,
Number
Millard.
one.
In the appeal.
Agora, respondent number?
He is the appellant, Millard. And here, of course,
IA.
IA, Millard, IA will be. IA, Millard, he has not been made a party, Millard, because opposite party has not been named otherwise.
Okay.
Page 3, Millard.
Okay.
Only I have been, Millard, named as an opposite party.
This application is referred by the applicant. For staying application of recovery of MSc award dated 7/23. First by the learned member authorization and interpretation was part of the MSc case for 409 2019.
उससे रिकवरी करने में आपको क्या प्रॉब्लम आप क्यों उसके सबमिशन दे रहे हैं
Initiated by the United
Enhancement के लिए आएंगे।
हुआ नहीं बात
present application.
Real तो कुछ नहीं।
106/169 for the MAX 9. Sir, Dr. Learned counsel for the opposite party submits that the granted of time by the object. There is according to the matter after 1 week.
2 weeks back.
Yeah, my name is shown as Arani shown as in the process.
Yeah, so the learned counsel submits that her name only reflected in that also. That's it. That's it.
Obliged.
Main appeal lordship.
That
Main
is not
appeal.
listed there. But it
This
is
is
not
for
listed there.
So this will kindly be listed in next Lokata. So winter में कर. This is for enhancement of.
There,
Pardon me?
is there any chance for
I don't know, but since now they are also filing an application here, it becomes a little complicated. Otherwise, perhaps it could have been settled. Perhaps. That we don't know. But now he is saying that the pain recovery should not have been given. All these things now will come into the picture. That is another issue.
M. Dr. Learned?
I'm for appeal and
No,
lordship.
no. Mr. Agrawal for the appellate. And Mr. Dr. for the appellate for
One.
And Mr. Yuko,
Hey, Rahman.
respondent number,
Two, well, two responses.
and number 2.
Two.
Who is for respondent number 3?
I think one appears.
No, he
appears. Yes, Is the SP on a vehicle, Nikki.
Okay.
Mirror.
19/6/2025. Meter editor not under respect of the mother. According to it provided that Learned counsel for the appellant shall take prescriptive of within a week from today by registered book with ADM by this matter after for
Obliged.
Obliged, your lordship. My lord, this element is a, my lord, new case. The first time is, there is a delay of, my lord, IA 2457, my lord. Delay is, my lord, 78 days. This is my lord, first time,
let notice go.
my lord.
Let notice go.
Yes, notice maybe. And then along with this, my lord, another item of the analogous case, that is 63 supplementary. Same, 63. One for, my lord, there also delay of 19 days. 63. A notice may be issued in, I'll take the step in both ways.
In both the next
My lord,
after for
my lord. And 63 also, my lord. My lord.
next side.
May I have lordship? First matter pertaining the provincial election lordship. So, may I lordship, the last occasion, Honorable Court is to direct it to the Respondent Council to submit the annexer 1, 2, and 3 lordship. The order dated lordship, which is reflecting 9/6/2025. Second paragraph lordship. The elementary department shall produce the ensure enclosure number 1, 2, 3 of the letter of the block elementary education officer dated 13/2/2014 before this court. And the next is considered is the matter considered.
The
So-
exit this enclosure or what?
Yes. My lord. This
Annexer 1 and
the annex, regarding the annexure 1, 2, and 3, my lord, we have given written to the department, my lord. We are awaiting our instructions regarding that. So, my lord, some lordship will defer the matter by a week, my lord. In the meantime, I'll get the full, my lord, instructions. My lord.
lordship, the last occasion also.
Because the SSA also, on the last occasion, my lord, we had entered, my lord. The SSA also was a party, my lord. Is a party. My lord will have it in the next week, my lord. I'll get the full instructions. Today, my lord, today I'm a little handicapped, my lord. The instructions not given to us fully, my lord.
Lordship, the same statement last.
1 week, my lord.
You have appeared on the earlier occasion.
Last occasion
Yes,
I appeared.
lordship.
I appeared on the last occasion. Man. I appeared on the last occasion. But however, when I have written, my lord, sometime, my lord, next week, my lord, I'll produce it.
You have written.
My lord, I have that time, that after the, my lord, matter was taken up, my lord, I've sent the order, my lord.
Are you sure?
Yes, my lord, some time may be given, my lord, a week's time, and we'll produce it. Week's time.
Yes, but
This matter is
A date may be fixed, my lord. A date may be fixed.
part theta. Anybody for SSA?
My lord, SSA,
Gogoi.
B. Gogoi name is reflected. He is appearing.
Is he present? For,
He is present. I have-
so we go for the SSA. So put that who has forwarded a copy of the order dated 25/7 of yet did not keep the order.
Wahnan.
And as for granting 2 weeks time, or is the same? It's a computer of it's a matter of
2-0.
deeply applied.
Yes, must have.
your lordship kindly peruse the last order.
They have been taking on time again and again, your lordship. It relates to payment of your lordship DA, your lordship. By this time, your lordship, we should have your lordship may only see the earlier orders, your lordship, your lordship.
Yes, but
Lord.
they have paid for days time.
Lordship.
This matter is under process as per this.
Lord. He has provided the copy.
I've given a copy of that.
Let us wait.
Lordship.
For another 15 days, madam.
Your lordship may fix it on after immediately after 15 days, and that may be the last chance your lordship may observe it. Because it seems long, your lordship has seen your lordship. They are taking time.
And they can- but it's better. Better. Dated
Is
5th
it?
August 5. That is time. Better taking. And also better. That's it is 50 time. But it's not, this nothing on. I fear that for further time to come.
Lord. Lord.
Mr. Kapayan,
Sorry, madam.
that
Deeply obliged by state.
for simply mark that
Deeply obliged.
May I please, your lordship, my lord, here in this case, also petition are paying for pension, my lord, monthly pension, my lord, and your lordship. Earlier occasion asked the Mr. Sharma to obtain necessary instruction that since file is before the government, my lord. Yes.
Now report from elementary has come and now it is a file is on the government department. So some time is required here, man.
Lordship also observed them to release the provisional pension also on. By your lordship, order 25/6/25.
Okay, don't think.
or sir along internet concept for the department. This is the finance department now.
My lord. Finance department is also party, my lord.
No, my lord,
Finance department is not a party.
Not
yeah.
party, email.
No. Is the matter with the finance department?
No, my lord. Now it is in the government department. File is on the government department.
Which department?
Secretary School Education.
No, Lord,
Mm.
the matter is pending to the secretary.
Secretary to the Government of Assam, Department of School Education.
Education department of the okay, so
Hmm.
which
Yes, 2 weeks.
that is accordingly allowed. But it's a better for the next right with the record according.
My lord, take with the time. My lord.
Lord, I have filed my IA for my lord, the vacation of the interim order. Here in this case, my lord, admittedly, my lord, Power Grid, my lord, took my lord some land for drawing there, my lord, how high power, my lord, electric line, my lord. And money was, my lord, substantial money was already admittedly, my lord, given to the, my lord, all affected person, my lord. Now, my lord, suddenly, one lady, my lord, filed one application for demarcation of the land, my lord, which, my lord, learned trial court declined, my lord. Then it is a dilatory practice, so it is rejected. Against that, my lord, this civil revision petition is filed.
It's IAS for what purpose?
My lord, my learned friend will appear for petitioner, my lord. I am for my lord, IML for vacation of the interim order he has obtained, my lord. He is plaintiff petitioner before your lordship in CRP IML.
So we may heard both the matter together then.
Yes, my lord.
No, so far this item 15 is concerned, I am appealing for 10 to 13. Well, I filed the affidavit because we are the power grid. We have deposited the amount.
We have no grievance against.
So there is no grievance so far we are concerned. Our presence, our names may be deleted, my lord, from here. That is our prayer, my lord.
From the CRP.
Yes. 10 to 13, my lord, they have no grievance, my lord, so far we are concerned because
Only because
amount is lying there, they are disputing among themselves. Yes.
Already received. The top back, my lord, is this part.
So it is within them, my lord. We have nothing to say, my lord. Well,
Yes, to I manage to.
so our presence is not important.
Yeah.
Unnecessarily, my lord, they have been with party.
Oh,
There are 7 we have said.
no. So I have
Yes.
there's no additional hearing there. Okay. Will not pass any order in respect to you.
Okay.
But we'll hear the matter.
My lord.
Your presence is not required.
My junior will be there, my lord.
Yes.
They may have my.
He may also.
Yes. My.
Yeah. CRP.
Yes, sir. She will hear this. I'm sure.
Are you ready?
Yes. So she may kindly see in this matter what happened, your lordship. The land over which your lordship, the power line was installed, your lordship, belongs to one Irfan Ali Borbuye, your lordship. We are the descendant of Irfan Ali Borbuye from voter side, your lordship.
Where is the impugn order?
Impugn order, your lordship will find at annexure 7, page number 91, 92, and annexure 9, page number 95. Your lordship. It has been dismissed on technical grounds, your lordship. It has been filed by the advocate, your lordship. Subsequently, lordship may find it at annexure 9, page number 95. We have corrected and filed another application. That has been rejected also on the technical ground, referring certain other orders. Does not hard on merit, your lordship. Now, lordship will find the orders which have been reflected in the impugn order dated 21/9/2023, page number 95. Annexure 10 onwards, I have annexed, your lordship. It was not fault of the applicant, your lordship, petitioner. The order that has been referred in the impugn order, your lordship, I have annexed from annexure 10 onwards, your lordship. Dispute is among the siblings, lordship. Among the siblings over the proportionate. Who will be the beneficiary of the zirat amount, your lordship? Brothers are saying that they are in possession. They will, as because we got married, your lordship, and deciding in a different place, your lordship, we are also entitled as per in a law of inheritance, your lordship. Now, they also admitted the fact that yes, we are entitled as per law of inheritance, your lordship. And in this regard, your lordship, petition number 4 earlier, that is my mother, your lordship, I instituted the petition under section 16(3), your lordship, under Indian Telegraph Act, your lordship, paying for that. Even in the cross, your lordship, the main respondent number 1, your lordship, has admitted if he has no objection, if so far as the share is to be decided, if a demarcation and assessment over which land the power line has been installed, your lordship, is demarcated, whether our land, our properties also got damaged, your lordship, proportionate share will be given accordingly, your lordship. As because we got married, your lordship, there it is not meant that we are not entitled, your lordship. And that is what we wanted to do, your lordship, filing a petition so that it can be demarcated, your lordship, so far as proportionate share is to be decided, your lordship. That has been dismissed on technical grounds.
What
That we are page number 91, your lordship. First, it was filed by the advocate, your lordship. It has not contained the signature of the applicant. On this ground, your lordship, it has been dismissed. Secondly, your lordship, again, another application was filed after the dismissal of the first petition, rectifying that defect. That has been also dismissed on the ground that
Where is that order?
page number 95 we find, your lordship.
Why this time was the
Page number 91 is the first impugn order, your lordship.
no, the second one, why it was rejected?
It was rejected. The matter is pending since 2015, but on the pretext of to the other, it is to the petitioner side who has been delaying disposal of the matter. The order dated 10/8/2022 and so would reflect the ways and means in which the petitioner side has delayed the disposal of the instant proceeding. Considering the above, and in particular considering the fact that order dated 17/8/2023 on the same issue has remained unchallenged, I am not inclined to consider the present petition. 17/8/2023
Petition,
present petition.
petition number 72.
Petition will, Lordship will find at Annexure 8, page number 93. Petition number 372 public 6. Lordship.
Page number.
Petition number.
Yes.
And order is 21/9/2023, Annexure 9, page number 95.
No, this petition is annexed.
Annexure 8, page number 93. Lord. This is the petition, Annexure 8, page number 90.
So, Mr. Corvina, do you have any objection?
My learned friend's contention.
My lord, we have objection because, my lord, at this stage, belated stage, my lord, demarcation is done by the, my lord, deputy commissioner, my lord. And it was done, my lord.
Tell me whether the petitioner is not entitled.
No, my lord, not entitled, my lord, and demarcation, my lord, is
So
not.
why not entitled?
My lord, their land has not, my lord, gone in this line, my lord.
Pardon?
In this, my lord, where my lord, power grid line was, my lord, drawn, my lord. His land is not involved, my lord. Yeah.
Whether
Yeah.
that was party.
Yes, my lord. This partition, my lord, therefore, my lord, this respondent before your lordship already received the money.
In this regard, Lordship may kindly see page number 43 for a moment.
43.
43.
Yes.
This is the cross of the main DW, Your Lordship. Bottom, Your Lordship. After partition, I sold the ancestral land to my sons. But no partition is submitted by me before the court, as there is no any written partition deed prepared after demise of my father. Thereafter, my sons cultivated the said land. Now, Your Lordship may kindly see from bottom. Second para. It is not a fact that the petitioners are entitled for compensation against the homes and trees of the homestead belonging to their father, and they are entitled as per law of inheritance. But I, in collusion with the revenue authorities, prepared the assessment against me, my sons, and my wife. He is my maternal uncle now. You're letting my mother die. And next para, I have no objection. No any specific boundary over which the power lines. No any specific boundary, Your Lordship. Next line, I have no any objection if the damaged land which are underneath of the power line by the power grid is demarcated on inspection. Now my learned friend is saying that I am not entitled. Even in his
You are reading page number 43.
43, this is the cross of the main DW, Your Lordship.
Yes. From which part?
Against whom my learned friend is appearing.
From which part you are reading?
Lordship, page 43, bottom. First, after partition, I sold the ancestral land. This is the cross of the DW1. After partition, I sold the ancestral land to my sons. But no any partition deed submitted by me before the court, as there is no any written partition deed prepared after the demise of my father. Thereafter, my sons cultivated the said land till now. The aforesaid purchase land of
Yeah, here the page number 44 is absent.
it starts from page number 43, Lordship. Type copy.
Yeah. Okay. 44 is after 45. Yes.
Written partition prepared after demise of my father. Thereafter, my son cultivated the said land till now. The aforesaid purchased land of my sons is far away, about the distance of more than so from the strength of power line. Now, from bottom, Your Lordship, middle of the, it is not a fact that the petitioners are entitled for compensation against the homes and trees as homestead belongs to their father, and they are entitled as per law of inheritance. But I, in collusion with the revenue authorities, prepared assessment against me, my sons, and my wife. No any specific boundary over which the power grid strength, power grid the power lines. I have no objection if the damaged land which are underneath of the power line by the power grid authority is demarcated or inspected. I have not submitted Jamamandi of the land which are underneath of the power line. Joshi, I have annexed the Jamamandi yellow. Now, Lordship may kindly find the assessment list as annexure 4, Your Lordship.
Page number.
Page number 56. Lord. Assessment list, serial number 1, Lordship, bold 121. I am not on 118. It's 121, 119, 382, 383, 384, and 389. This is the Patta and Dag number, Your Lordship, against which we are claiming compensation, Your Lordship. Now, Lordship, right side, on the next page, page number, Your Lordship, against you will find, Your Lordship, page number 58. Same Dag numbers, Your Lordship. In this way, Your Lordship, we have also lost complaint against this. Lordship will find it at page number 82, Your Lordship. Because there are various other cousins, Your Lordship.
It's for 82.
82, Your Lordship. Right side remarks. Objection 5. Now, Your Lordship, may kindly see page number 84, annexure 5. Page number 84, annexure 5, Your Lordship. This is the copy of the Jamamundi, and this is the Dag number 380, 380, 380, 384, Your Lordship, against which we are claiming, Your Lordship. And in his cross also, Your Lordship, he has stated that he has no objection, and he also he did not submit the petition, and also, Lordship, the fact that he has admitted the fact that we are entitled as per law of inheritance, Your Lordship. As because, Your Lordship, my mother got married and staying in a different place, Your Lordship, we are also entitled so far as the compensation that has been paid. Against that, Your Lordship, we have filed a petition under section 19(4), Lordship, may for a moment, Lordship, may kindly see, of the Indian Telegraph Act. My learned friend is saying that I have to file a money suit, Your Lordship, in this regard.
Section
16(4), Your Lordship, surplus proof. Section 16, subsection 4, Your Lordship. If any dispute arises as to the persons entitled to receive compensation or as to the proportions in which the person interested are entitled to share in it, the telegraph authority may pay into the court of the district judge such amount as he deems sufficient, or where all the disputing parties have in writing admitted the amount tendered to be sufficient, or the amount has been determined under subsection 3. That amount, and the district judge, after giving notice to the parties and hearing such of them as desired to be heard, shall determine the persons entitled to receive the compensation, or, as the case may be, the proportion in which the person interested are entitled to share in it. That is why, Your Lordship, we favored a petition under section 16, subsection 4, Your Lordship. Why they are in hurry, Your Lordship? Because Lordship will infer from the fact, page number 100, Your Lordship.
So, Borkuya,
My lord.
there is no dispute that the petitioner is also person interested. Then entitled to share.
And only thing is that, my lord, procedure, lordship, kindly will look their prayer, my lord, in the main case. Main case, my lord, it is a long process, administrative process initially, my lord, it is done, my lord. And it is revenue authority who demarcated the land, my lord, and he made out the list, my lord. And payment is also made, my lord. As per my instruction, my lord, 90%, my lord, compensation is already my lord, given to the my lord, affected person, my lord, including.
But tell me whether he is not the person interested.
But my instruction is that, my lord, he is not, my lord, interested. Had he was interested, my lord, definitely his name would have been there, my lord. When it was demarcated, my lord, it is not done, my lord. And my instruction is that, my lord, as matter from the lower court, my lord, trial court, my lord. Here, my lord, advocate concern is more interested. Therefore, immediately at first, my lord, advocate, he directly filed the application. And he is bargaining with the, my lord, my party, my lord.
Later on, the petitioner has signed.
Yes, my lord. Subsequently, my lord, when advocate's application was rejected, and he is bargaining with the my lord, the petitioners, my lord. And subsequently, my lord, plaintiff also filed another application. That was also declined, my lord. But here, my lord, main fact is that, my lord, demarcation, my lord, earlier what will happen to earlier demarcation, my lord? At this stage, my lord, only to harass, my lord, and to bring them, my lord, down for compromise, my lord, but and my lord, council in the, my lord,
They are so anxious, Lordship.
trial.
Kindly-
And I have stated also in my IA, my lord. IA, my lord, in
They have
paragraph.
managed the authority concerned. And
That is all, my lord,
Lordship
not in
will
the
find
revision.
it is from the court's order.
Petition.
Page number 100. I'm just reading your Lordship. By first petition, it is stated that in spite of the order dated 12/1/2017 passed by the predecessor of this court, the petitioners came to know that opposite parties, that is Deputy Commissioner Hailagandi and the Power Grid officials, in connivance with the opposite parties, disbursed the remaining payment in favor of the opposite parties. Thereupon, this is necessitated to call a report from the office of the Deputy Commissioner Hailagandi as well as from the Power Grid Authority as to whether any further payment was made by the parties or not. In this regard, your Lordship will find page number 103, second para, your Lordship. What court has observed.
10.
103.
Yes.
Accordingly, the Power Grid Authority responsible in this regard as well as the Deputy Commissioner Hailagandi are hereby directed to submit a report as to whether further payment was made to the opposite parties in spite of the order dated so, and if so, the amount to whom it was paid must be mentioned specifically in the report. So that is under, as because it has been stayed by this honorable court, it has not proceeded further, your Lordship, in this regard. It will come out, your Lordship, we will have to submit because we have filed our objection also. And we have no other place to go, your Lordship, except under section 16(4), your Lordship. And Lordship, I have cited two judgment, your Lordship. Honorable Apex Court also decided that it is the situs of the land as well as, your Lordship, the situs of the land, the distance between the high voltage electricity line thereunder, the extent of the line thereupon, as also the fact as to whether the high voltage line passes over a small tract of land or through the middle of the land, and other similar relevant factor in our opinion would be determinative. The value of the land would also be a relevant factor. The owner of the land, furthermore, in a given situation may lose his substantive right to use the property for the purpose for which the same was meant to be used. Though it is not directly related in the instant case, your Lordship, but what should be taken into consideration? That is why we have filed a petition, your Lordship, whether our land was damaged or not. If yes, then we are entitled for proportionate share, your Lordship.
Which paragraph you have realized?
Lordship, with SSC 2007-6, 792, yellow paragraph 10, your Lordship. 2007-6 SSC 792, your Lordship, paragraph 10. And another one, your Lordship, paragraph 1 and 2. Just for the fact that, your Lordship, what are the relevant factors that is to be seen, your Lordship, that is to be considered, your Lordship. Here, though it is not directly relevant, those citations are in the present case, your Lordship. What I am trying to submit, your Lordship, unless it is determined whether our land has been damaged or not, then only, your Lordship, we can claim.
Whether at the time of acquisition of the land, notice.
Land was not acquisition, Lordship. In this, under Indian Telegraph Act, land was not required to be acquisited, your Lordship. Owner will be remain, only they will use. And for the damage, then section 10D, your Lordship. Land is not required to be acquisited.
When the process was started, the topic was
Even no, they are not required to issue any notice also, Your Lordship, by virtue of this. Yeah. The power for telegraph authority to place and maintain telegraph lines and posts, section 10, Your Lordship. The telegraph authority may from time to time place and maintain a telegraph line over, along, or across, or post, or upon in any immovable property, provided that the telegraph shall not exceed the power conferred by this section, except for the purpose of telegraph established, maintained by, or to be established, or to be maintained. Page 91. Section D, 10D. In exercise of the powers conferred by this section, the telegraph shall do as little damage as possible, and when it is exercised those powers in respect of any property other than the referred in clause C, full compensation to all persons interested for any damage sustained by them by reason of the exercise of those powers. Power to enter on the property in order to repair or remove, that is different. Only they will use the land for installation of the power line, and they will try to do little damages, Your Lordship. For that, they will not take the ownership, Your Lordship.
all parts are interested. Here it is mentioned. The authority shall pay compensation to all parts of interest for any debt. So the land is not partition, then there is not a person interested in the land.
And my lord, another aspect is that, my lord, in their petition, my lord, I have seen, my lord, there is no mention in the original suit and present application also, my lord, which is the land, where will be demarcated, my lord. There is even no whisper, just demarcate. And it is a, my lord, long, my lord, hundreds, my lord, kilometer long line, my lord, is gone. So far I know, my lord, till Tripura, my lord.
Refer
And
the
it is
tag numbers and patta numbers also, against which objection has been filed.
their petition, my lord, page
Written
93.
statement also, Your Lordship, they have admitted.
This is separate thing, my lord. Page 93, my lord. Their present petition and, my lord, and after, my lord, 10 years, my lord, they are seeking, my lord, demarcation. Where, my lord, revenue department will go, my lord, and where it will be demarcated. It is only, my lord, to create pressure, my lord. My instruction, my lord, and I have also stated in my IE also.
Also submitted reply to the IA.
No identification of land, my lord. Nothing.
Where is the description of the land?
You will find that page number.
My humble submission is that, my lord, that demarcation aspect of this type of, my lord, action is very primary, my lord, step. And case was filed, my lord, in the year 2015, my lord. And now, my lord, in the then also, my lord, there is no description about the land in their plain, my lord. And now, my lord, after almost 10 years at belated stage, my lord, without giving any description of the land, my lord.
Page number 21, your lord.
No, in the petition where you have
Page number 21, schedule of land, your lord. Page number 21, your lord. Correct. This is the land 389, dark number 390, 382, 384, 384. That has been in the assessment list also you have filed up.
Yes, Mr. Bormina.
Yes, my lord. Their present petition, my lord, page 93, my lord.
No, what is this first sentence?
16, my lord.
1/6.
1/6.
Section 1.
16 is the
Petition under section 64 of the
yes. That is
Yes, my lord.
if any dispute among the beneficiaries, your lord, then petition lie under 16(4).
You come to page number 21, there the boundary has been given along with duck number and pata number.
Lordship will also find annexure 4 in the assessment list also we have in the not all the ducks, certain ducks, your lordship, I made bold. Is number 56.
Yes, the Bormina got it.
My lord. My lord, in that, my lord, it is schedule of the land is given, my lord, page 21.
So demarcation has to be over that plot of land. Yeah, but
Obliged.
Obliged.
what's the matter? I clearly
My lord.
will pass the order.
Obliged.
Why not?
Yes.
My lord, during the pendency of this civil division petition, initially status quo order was passed. It was the basis of a report of the Lat Mandal, a preliminary decree was drawn up. The basis of a report of a Lat Mandal, which has to be done by the deputy commissioner or any gazetted officer. However, during the pendency of this matter, my lord, the final decree, there was order passed to drop a final decree. So that's the difficulty, my lord. Therefore, this application is currently infructuous. However, I'm only one prayer, my lord, that we may be allowed to raise our grievance before the learned civil judgment.
Learned?
Civil judge Singh Shukyam. In respect of the final. Because the final degree, lordship is aware that before drawing up a final degree, further inquiry is required. That was not done. Be that it may, my lord, this petition is infrastructure, so we are like to withdraw the petition. Yes, yes. With that liberty, my lord, that we raise our grievances before the yes, before the court below.
But with regard to liberty, my lord, for this final decree is already prepared. Suit is disposed of, my lord. So if the senior friend wants to challenge this decree,
I'm not
then he
challenging,
file
my
the
lord. I'm
appeal,
not
my lord,
challenging.
because the suit was disposed of, my lord. So nothing survives before the court, my lord. My lord, this is the order of preparing the final decree, my lord.
That I've got, my lord. My friend in given.
After preparation of final decree, my lord, the court, nothing is before the court, my lord. If he wants, he has to challenge the decree, my lord.
Decree unless executed, my lord, this is a partition decree. It is not other decree. Partition decree, my lord. The partition decree unless executed, it has to be executed, my lord. Therefore, I have all the rights before the court below.
Okay, if the same is permissible under the law.
Yes, ma'am. Yes, ma'am. Yes.
Or the we also learning council for the learning council assisted by the
It does.
learning council for the petition for the contact. The total learning council for the petition by the statement before the court that during the pendency of this petition, final decree has already been drawn up by the learned civil judge senior division Pichukia. And as such, this petition becomes further. And as such, he prays for granting, prays for according in part of withdraw this petition with regard to raise by defense of the learned civil judge senior division respect of the final decree. Final decree. Taking the submission of both the parties of the learned allowed to do this. However, but the raise his defense for the learned civil judge
In accordance with law,
within the senior division.
my lord.
Right.
May please be, my lord. Course, this appeal is prepared by the claimant on a EC Act lordship for enhancement of the compensation lordship. And we have formulated substance question of law in
Appeal is yet to be admitted,
yes, lordship.
but we have the substantive question.
Yes, lordship. Page number 9, para number 9, lordship.
Or-
Interest award is 12% though, but it is conditional. That if payment is not made. So that should be from the date of accident lordship in WCF. And income is taken 8,000 as per the ceiling, but it proved income is 15,000 plus 100 be daily allowance, 18,000 loss. And this notification, whether it is applicable in the present case or not. By this notification, lordship, that 15,000 has been 8,000 to 50,000 has been made by this notification, lord, for the worker in place ceiling.
Your Lordship, I am appearing for respondent number 2, but I haven't been served with the copy of the appeal.
I'll supply you.
Do you have an objection respect of the substantive question?
Otherwise, I think the appeal may be admitted.
It may be,
Yes, Your Lord.
but respect the of
Your Lordship, I'm not aware with this.
yes.
Interest. Income interest. What is it?
But Mr. Agrawala learned it from letter and insert of part
2, Your Lord.
part 2. Who is the respondent for 1?
Owner of the vehicle.
Part of the vehicle. It's 30 under 630 and 1 of the workman company. It's directed against the 35 1 outside the learned company. So it's approved and 1 publicity is for 50 of be declared that by judgment and ever did it the learned company employee compensation from them was it directed to A is approved 25 lakh.
Yes, sir.
Take the company the what is the amount of compensation? 8 lakh.
8,47,560
Then
Lordship.
why this value of the appeal is shown as 25 lakh?
Button Lordship.
Page number 2. Value of the appeal is shown as 25 lakh. Why?
Page number 2 Lordship. That is claim amount Lordship, 25 lakh.
Lakh 47,500. The appellant hearing. Produce the memo of appeal and the grounds mentioned there. Produce the award date. Yes. Appeal is admitted on the following substantive. Number 1, whether acting of the learned commissioner is perverse in respect of conditional interest award and in not awarding the interest from the date of accident. Number 2, whether the learned commissioner are in not awarding daily allowance to the salary extra wages was paid to the deceased workman for rupees 18,000 including daily allowance and salary is proved at rupees 15,000 monthly per month per and daily allowance at the rate of 100 per day. number 3, whether the claimant is entitled to enhancement of monthly wages as enhanced by latest notification number SO bracket 71 E dot dated 3rd of January 20. An actual proof wage is required to be considered. Number 4, whether or not the learned counsel was hard, whether the learned commissioner was hard in taking monthly wages of the deceased driver up to the fixed ceiling as notified by the central government. While computing compensation, though there was positive evidence that higher salary was paid to the deceased. If the notice to the respondent return evidence for it, one of the office is required.
I'll settle the report.
Respondent number 2 also entered evidence. Extra copy of the memo of appeal is furnished with also the take up on section number 1 being taken by it. Essential for the record.
Much up.
Please, Your Lordship. The revision was filed against the order dated 5/2/2025 passed by the London Civil Judge Junior Division in case number 37 of 2024 Lordship. The impugned order is at page 85. And it's at J. By which the petitioner was respondent was allowed to additional evidence in the execution proceeding. Lordship.
So you have filed objection to that petition.
Yes, that's it.
And you have filed that objection in this petition.
Lordship.
Page number.
After that, that objection I have brought on record by the additional affidavit, Lordship. Filing additional affidavit. Running page 97 of my additional affidavit, Lordship.
Okay, we'll pass the order.
Lordship, in this case, Lordship, policy in question was valid in respect of third-party insurance, Lordship, and victim was traveling in the insured vehicle, Lordship. So his risk is not covered in the policy, Lordship.
Okay. Third, appellant. with appeal under the Act, citing the judgment and award dated 23rd 12th of the learned member motor incident claim terminal now now of the declared by the court the third act directed the appellant herein to pay a sum of something like 30,000 on the company respondent number
Number
one
1 and 2.
one and there is the memo written in the ground and bearing that the judgment in the court is third of admitting for the be taken by an expert within the rest of the record the learned web place the matter under for I take the this I number 508
That is for stay lordship.
stay officer is the second it's interlocutory application under order 45 dated 6 what it is 24 what it is no count it is the previous subject connected habit has occurred and it is recorded also notice that opposite part and six it has already been admitted there is a work for state award with its students and that the applicant is ready to person or erratic the top for the applicant operation of the judgment and order dated to the state till disposal of the MSC appeal numbers. Subject, however, to deposit 50% of the awarded amount is the court or expired today.
So one,
With high
here's another I lordship to allow us to reduce evidence lordship, the evidence.
Thank you.
Is an appeal for enhancement.
Lordship, I have a simple prayer, my lords. Lordship, we came to know the order of the Honorable MSCT after receiving the copy of the memo of appeal of this present appeal, my lord. We came to know that none appeared for the OP number 1. I'm appearing for the transport department. Here, transport was made as a OP number 1. Though we have it's a ASTC matter, my lord. We are the formal party. But surprisingly, the learned MSCT has directed the OP number 1 to release the compensation. So, Lordship, we need to take appropriate steps before the learned. The pendency of this appeal may not be about this is my simple prayer, my lord. Though we have directed in the year 2023 ASTC to do the needful, they have not appeared there. So expert to order a spot against us, though we are formal party. ASTC is the main respondent.
who is the owner of the vehicle?
Yes, Lordship. ASTC.
Yes.
ASTC.
Then who will take of it?
ASTC. Then direction is given to us OP number 1. The Lordship will find that page, my lord. The observation of award, page 26 of the appeal memo, my lord. Page 26, last para, my lord. Award.
Yes.
Award matter, may I read matter 48. In the result, the claim petition is allowed on contest and the claimant are entitled to get total compensation amount of his expenses for the death of the deceased. OP number 1 is the directed to pay the said compensation. So OP is the transport department. We are the formal party. Is the ASTC who is the main respondent. Is the OP number 2, ASTC. So we need to file appropriate steps before the learned. Pendency may not be a bar, my lord. We came to know about this judgment after receiving the copy of the appeal memo, my lord.
Tell me whether ASSA is not under the transport department.
But there is a corporation. Corporation under the board of director. In fact, there is a direction from this honorable court in a matter. We have nothing to do in the ASTC function, my lord. This honorable court has clarified.
Or the verdict is Assembly Board.
One, my lord. Here also ASTC is a party, but their name is not reflected in the cause this.
This subject number 6 within direct ordered within 5 number one in MSC case number 595 of the declared by the ordered directed the respondent for
one
hearing to pay a sum of 75,8,477 for being the compensation the appellant
Appellants.
to the appellant. Peruse the memo of account and also peruse the judgment and order dated admit notice to respond state of respondent for 20 taken by desert post with AD and also by the process. How much of our notice favored the test for one empty Bora?
Transport department.
Or one entered every how about entered in parts are Bora the vehicle belongs to the destination number 2.
Lordship.
Destination number 2. Destination number 1 has nothing to say. But by the judgment, never did it to the verdict that directed the destination number 1. Pay the compensation. Its Bora further submit the respondent number 1 the formal party. And the party to raise the issue to the tribe. But the case has already been discussed of there. So I'll review it.
Lordship, we need to take appropriate steps, my lord, to correct modification of this. Tendency may not be a bar, lordship.
So the submission of verdict to the part it is provided that tendency of the subject does not be bar raising the issue by the respondent number 1 to the verdict tribe. Subject or
I'm so deeply obliged, my lord.
There is one aspect, man. Since the appeal is already filed here.
Yes.
Now the entire subject matter is seized with this honorable court. How the tribunal will look into that aspect?
they will file a review.
Yes.
The lordship has called for the LCR.
Yes.
The next date, my lord may call for the LCR because in the meantime, we will file a review. Not today, my lord.
Okay, on next day we will
Yes, yes.
Or she may file a cross appeal here also.
in the epilogue. So that is one
That of
obvious.
Yes, we'll do the needful, my lordship. Lordship may kindly observe the transport department do the needful. Whether we may go for
department,
my lord.
Yes.
no, no leave is required.
My lord.
File a cross objection. Yeah.
Lordship.
Obliged.
I'm so deeply obliged, lordship.
May I please, your lordship? Lordship, this is an appeal for enhancement of the award, my lord.
What is that?
Zaman. Lordship, the respondent number 2 and 3, they are the owner and drivers. So their name may be stuck off, my lord, because the appeal is preferred to the extent of enhancement only.
Or the document this appeal under order under the because what the 1988 is directed into the award 5,000 award. Directed by the award is directed the estimate number 1. Yeah, estimate of the is about it is the amount of compensation.
Lordship, the total amount of compensation is 9,84,000, Lordship. Page number 11.
Plus 84,200 being
Yes.
the compensation.
Award is to be
The
satisfied.
balance with interest at the rate of 7% per annum. The rate of filing the claim petition that 65. Where is the memo of implemented down hearing? It's notice to the respondent returned for which the ticket by registered to ADN of the process. The learned counsel the appellant submits that this appeal is deferred for enhancement of the compensation memo. And as such, the respondent number 23 who are the driver and owner of the vehicle are not a necessary party in this appeal, and as such, they are named as track of the area of this appeal. They are taking the submission of learned counsel, the appellant is provided that the name of respondent number 23 is track of the area of this appeal, and the cost and takes the appellant. Yes, still call for the record from the learned please the matter after for
Obliged, Lordship.
I think in this case, silence is the order for pay and recovery, lordship. In the old act, there was provision for pay and recovery, but in the new act, there is no provision for pay and recovery. Primarily. These are content.
award was passed under which act? New act or old act?
New act, lordship. 2023 case, lordship.
Or is there a क्या learned appeal of the award dated 25/4/5 of the learned here by the learned has directed the appellant pay a sum of rupees
2,77,469.
2,77,469 9 to 8. And remove the thing from the respondent number
Phone number one.
one. Number one. Okay, learn it better. Learn it for the people and subset. The award was passed under the amendment act. And in the amendment act, there is amendment or new act?
New Act Lordship 2019.
New act. Third and new act. And the new act there is okay. And as such, order is the legal chief judgment about it. And therefore, prepare the topic. So yeah, it's order considered. That is that means the bit of the response. Return a product step taken by the report taken of the record product record. IFO state
Still okay.
50%.
Already.
This is an appeal for enhancement. Let me issue notice and
After 4 weeks,
trial court record lordship.
yeah.
25.
May I please wish. This appeal filed by the claimant for enhancement of the awarded amount. This may go and check.
After 4
Call. PCR may call. PCR may. Publish.
For respondent claimant, this is for admission lordship.
So where is the council? Unappealed to the appellate of how about the record? You have filed caveat there.
Yes, lordship.
Caveat to be art.
Lordship, next Monday, lordship, that may come in. Date may kindly fix. My name is, my name may kindly be shown in that mainly.
This shall reflect the name of Agora.
Right, please, lordship. If telling this simple judgment and award dated my lord 27 to 25. In this case, my lord, the insured vehicle, the appellant is the truck which was standing the side of the left side of the road. That the deceased who was riding the vehicle along with the pillion rider.
Okay.
So dash behind the truck. But they have submitted, exhibited only the Form 54, nothing else to prove the case. Then we have adduced evidence and by defense witness, and also the police has also come and it is saying that the GDNT only. There is no anything is, they have not filed the FIR, only GDNT, the
Okay,
file.
okay. We are not hearing the appeal on merit today. We'll admit.
Well, admit and there is a
Awarded amount is 11 lakh 3,000.
my lord.
From the date of
From the date of
the
filing.
Yes, with 9% difference.
The IAS for stay because in the my lord, the pillion addresses file it is dismissed. I have to annex this case.
Okay, you deposit 50%.
My lord, 50%, my lord, we have no liability.
We will say later on.
Well, stay this.
We will return it.
My lord, at least stay maybe on the
We'll
returnable.
stay, but you have to deposit 50.
My lord, we deposit the rest.
Yes, before
But
that. within 4
But not withdrawal is at this stage, not withdrawal by the claimant. We'll take the state.
We'll pass any order
No,
in
no.
that regard.
But stay may be granted with
Yes, subject to depositing
50%. Much of it.
May it please the Lord. Second appeal, my lord, against the concurrent finding of fact. But may I just give the actual background, my lord? But I was the defendant in this suit. Plaintiff number 2 and the defendant number 3 who passed away in the meantime, my lord. They are siblings, my lord, brother and sister. But admitted position is that in the year 1993, my lord, on 23/6/1993, the plaintiff number 2 issued a power of attorney in favor of the defendant number 3. Now, my lord, on 5/1/1996, when the power of attorney was in existence, my lord, she executed a gift deed in favor of her son, who is the plaintiff number 1 and respondent number 1 herein. Few months thereafter, the defendant number 3, my lord, he executed a sale deed on the strength of the power of attorney to his sons, who are the appellants herein, my lord, who are the defendants in this suit. Now, they filed a suit inter alia, my lord, for declaration of right, title, and interest, and also for setting aside the power of attorney as fraudulent, my lord. Prayers are at page 12, my lord, of the suit.
page number?
My lord, page number 12 of the memo of appeal. My lord, both the learned courts below, my lord,
Prayer number?
No, my lord, the prayers are 10 in number, my lord. They have prayed for declaration, for handing over possession, and as well as for declaration that the power of attorney was forged, my lord. That is prayer number F. The things are very small. Type copy is very small, madam. That the power of attorney is forged, madam. Now the trial court has held that the trial court and the appellate court first appellate court has held, my lord, that the power of attorney is not forged, it is genuine. The second finding rendered is that on execution of the gift deed on 5/1/1996, my lord, the power of attorney has by necessary implication been withdrawn, revoked. I'll come to that. These are the points I'd like to urge, my lord. And because the power of attorney has been revoked by necessary implication, my lord, the sale deed executed on the strength of the power of attorney is void ab initio. These are the findings. Now, my first ground of challenge is, my lord, that this power of attorney, that the sale deed which is under challenge is dated 29/3/1996, and the suit is filed in the year 2013, man. In the suit, it is pleaded that in 2012, I had tried to dispossess them, and then they came to know about the sale deed. I mean, cross, my lord, PW1 admits that he had knowledge about the sale deed from the year 1997. May I just take your lordships to the cross, my lord? Type copy starts from page 23.
Yes.
If we come to the middle portion, my lord, sentence starting with, I have applied for mutation. 8th line from the bottom.
Yes.
I have applied for mutation of my name over the suit land, but no mutation is granted in my favor. I have applied for mutation in the year of 1997, and the same was cancelled in the month of August 97. I have not filed my mutation application and rejection order of the same in the suit. It is fact that my mutation application was rejected in the month of August due to exist of registered sale deed number 846 of 96 dated 29/3/1996. Then lordship kindly turns to the next page, my lord, page 24. Top paragraph, my lord. from fourth line from the top, my lord. I'm reading from the wide order dated so and so. I know the sentence starting. I know about the said mutation order dated so and so since the year 1997 till date. Till date, I have not challenged the said mutation order. In the said mutation order dated 29, it has been mentioned clearly that the mutation was granted by virtue of purchase and possession. So, well, admittedly, he knows that since 1996 there is a sale deed. He knows from the year 1997 that the sale deed is in existence. Yet he files the suit in 2013, my lord. The issue of limitation is not even taken up as an issue. Although, my lord, the Limitation Act mandates that even if it is not taken up as a defense, my lord, it is the burden of the court to decide the issue of limitation. Now, the second point which I will urge, my lord, is that both the learned courts below have held that under 207 of the Contract Act, when the principal, in spite of existence of a power of attorney, if the principal decides to act independently, it amounts to revocation of the power of attorney by conduct. The learned appellate court, my lord, has relied upon a judgment which is reported in 2024 8 SCC, my lord. I have a copy. But that judgment says something else, my lord. The learned court below has interpreted it in a different manner. Now, 207, my lord, lordship knows 207 has to be read with 208. 207 says that if by conduct the principal acts in a manner which is contrary to the agency created, my lord, then it is terminated by necessary implication. But 208 says that such termination does not take effect vis-a-vis the agent until such thing is communicated. The appellate court comes to a finding that since the defendant number 3 was a brother of the plaintiff number 2, it is presumed that he had knowledge. It is not pleaded, but it is not even their case that they had communicated, because their case is that the power of attorney is forged. Now, if your lordship takes up the judgment, 2024 8 SCC 351, my lord. In fact, the issue of limitation is also dealt with here, my lord.
Which paragraph?
First, I'll take your lordships to that part of limitation, my lord. In the head note part at page 352, my lord, I'll take your lordships to the paragraph. 352, if your lordship comes. Applicability of limitation has a different perspective. So, starting point is when right to sue first accrued to appellant. Admitted case of respondent is that appellant is a US citizen and she stayed abroad. Therefore, unless it is clearly established as a fact that appellant had knowledge of sale deed, it cannot be inferred that appellant had contemporaneous knowledge of sale deed and limitations started running from date of execution of sale deed. That apart, another fact is whether POA's question is void or voidable, and this depends on impact. Here the facts were slightly different. Here what had happened, there were two sisters in this particular case before the Supreme Court. There were two sisters. One had given the power of attorney to the other on the ground that when I am not staying in India, you will have the right to sell my property. But she was in India. She executed a sale deed herself with knowledge. There, under those circumstances, Supreme Court held that by necessary conduct, you have terminated the agency power of it. For that purpose, Lordship will kindly come to paragraph 28.
In paragraph, this issue was dealt with by
Issue of termination.
This
Limitation. I'm coming to that. From paragraph 19, page 363.
Yes.
We examine the plea of limitation raised by the respondent. The respondent's case is that the suit was filed on 11/5/2011, and in effect, the suit seeks to set aside the sale deed dated 16/4/2008. The suit was filed beyond the limitation period and should have been dismissed. Limitation is a question of law and fact. The period of limitation and the time from which the period begins to run depend on the article in the schedule appended to the Limitation Act of 63. The case falls under Part 3, suits relating to declarations. Article 58 reads thus. Description of the suit: to obtain any other declaration, 3 years when the right to sue first accrues. The words "when the right to sue first accrues" have been interpreted and held by this court in so and so. The starting point for the limitation in the case of setting aside sale deed has two limbs: the date of execution and the date of knowledge. There is no difficulty in applying the period of limitation expiring 3 years from the date of execution, provided that the appellant had knowledge of Exhibit A5 on the date of registration and the right to sue first accrued. The respondents in the circumstances of the case failed to establish the appellant's knowledge of the execution of Exhibit A5. In the final analysis, Exhibit A5 is held as without authority and void. The applicability of limitation has a different perspective. So the starting point is when the right to sue first accrued to the appellant. So that is my case, madam. The right to sue will be when starting point of limitation will be when the right to sue first accrued. And in the cross, he admits, my lord, since August 1997, he had knowledge. So the right to sue first accrued in August 1997. So my respectful submission: the suit filed in 2013 is barred by limitation. That is the first limb of argument. Second point, lordship will turn to paragraph 28. Now, this judgment, my lord, covers both the points I am trying to urge before your lordship. And this has been relied by the appellate court. Para 28.
Whether that was framed by the trial court and the appellate court.
For the point issue of limitation, no. No.
You have taken the stand that your
First appeal. In this, before this honorable court, I have taken.
no, here you have taken, but trial
In the
trial
trial court, the issue was taken. Point of limitation was taken. It was pleaded in the WS. I'll show.
but no issue was framed.
No issue was. No, even if I go to the extent, my lord, even if I do not take the point of limitation, my lord, the Limitation Act mandates that even if it is not set up as a defense, the court has to decide. The second point is pure and simple, my lord. The power of attorney is held by the court to be valid. Power of attorney was in existence when the first gift deed was executed. So the point of law which I am urging, my lord, that simply by executing the gift deed, will the power of attorney be terminated by necessary implication without the fact of giving the gift deed being communicated to the power of attorney only.
It's a requirement.
It is a requirement. That is what I want to show, my lord. Lordship will kindly take up the Contract Act. My lord, I was trying to develop a point that when a power of attorney is given for executing a sale deed, my lord, it creates an interest. But this judgment says otherwise. Lordship will kindly take up 207 and 208 for a moment.
Yes.
207 read in isolation will say that it is terminated. Revocation and renunciation may be expressed or may be implied in the conduct of the principal or agent respectively. Now 208, man. The termination of the authority of an agent does not, so far as regards the agent, take effect before it becomes known to him. I am on that. And I cannot argue a case that once a power of attorney has been given, unless the power of attorney creates an interest. Well, power of attorney can be like this, well, that A has some money to be paid to B. A gives the power of attorney that you sell the property and you take whatever money is due from me. There it will be a case of creation of interest. Or, my lord, someone gives the land to a builder to construct. Then it will be creating an interest. Then it cannot be terminated in violation of 202. But otherwise, a power of attorney can very well be terminated by necessary conduct. But that termination does not take effect unless the same is communicated to me. And that is what has been held by the apex court in paragraph 28 of that judgment. In fact, it is quoted by the learned appellate court. Then the learned first appellate court goes on to hold that the knowledge, my knowledge is presumed because I am the brother. So if that be so, then the knowledge of the plaintiff should also be presumed that he knew about the sale deed because he is the sister. 28 months. From a plain reading, section 208 infers and gives effect to revocation upon the twin conditions being satisfied. Number one, communication to the agent, and number two, knowledge to the third party. That is, one who deals with or is likely to deal with the agent. Then the revocation of authority becomes known to the agent and the said third parties. In other words, an idea in the mind of the principal to revoke cannot be construed as implied revocation or renunciation of agency. There ought to be an act or conduct of the principal which implies that the agency is revoked or withdrawn. If the revocation is expressed such as by publication in newspapers, public notice or advertisement, communication to the agent, etc. So these are the modes, my lord. If you are terminating the agency, you have to make a public, either you make a public advertisement, you give a public notice, or communication to the agent. The parties who deal with the agent have a reasonable opportunity to know the revocation of agency of the principal. Two stages of revocation are, firstly, one dealing with the agent, and secondly, one applies to the third party.
Sir, Tekka, you tell me where it is provided that section 327 has to be read with
Lordship reads to the paragraph 27, madam.
27.
Yes. Because 207, if read in isolation, will mean that you can terminate at any time. 208 says that such termination will not have effect till the agent comes to know of such termination. 27, in the absence of a particular mode suggested for revocation of the authority of an agent, the manner adopted by the principal to revoke the authority of the agent must be one which clearly and unequivocally communicates to the parties that is to be affected by such revocation that the agent's authority has been withdrawn. In the framework of sections 207 and 208 of the Act, the revocation, renunciation of authority may be made by express words or by implied from the words and conduct of the principal, namely, which is inconsistent with the continuance of the agency. This is one facet of renunciation or revocation of authority of an agent. The other facet is governed by section 208 of the Act. Section 208 provides for the effective time and date of termination of the agent's authority and third party. Then coming to paragraph 28, the apex court has said that you have to communicate. Now that is my second ground. I can show your lordships the finding of the first appellate court.
Tekka will read it at
That too.
Because when I go.
2024, 865. Made pleasure, lordship.
Yes.
I've almost completed, my lord. Only thing I'd like to show the finding of the learned appellate court.
Page number
98, my lord. If your lordship is kind enough to take up 96 first.
Yes.
96, my lord, this judgment which I have referred, my lord, that is relied upon, my lord. The paragraph is quoted from 96, paragraph 47. Same as Thankama George versus Lily Thomas is quoted. The learned court below, my lord, takes note that requirement of 207 and 208 and at 98 para 48, this is the finding. Married. In our suit, there was no specific clause in Exhibit 3 regarding its revocation. Apparently, there is no revocation deed in the record, but the plaintiff number 2 had executed the Exhibit 3 in favor of plaintiff number 1, thus applying the judgment of so-and-so. In our suit, it is seen that attorney so-and-so had impliedly revoked the power of attorney by executing the Exhibit 2 in favor of plaintiff number 1. The defendants in their written statement though claimed that they came to know about the gift deed after receiving summon of the suit, but I find it difficult to believe that defendant number 3, being his own brother of plaintiff number 2, was not aware of the exhibit. So the basis of the finding is, my lord, that since the brother, he is the brother, he ought to have known, my lord, it's a presumption. It is not even the pleaded case of the plaintiff that they had communicated. It could not have been because the power of attorney is alleged to be forged, which of course both the courts below have held to be valid. But in the aforesaid backdrop, my lord,
whether you have adduced any evidence to establish that the power of attorney was forged?
no, the finding is the power of attorney is valid. That has not been challenged.
No. Your case is
Power of attorney is in my favor, ma'am.
forged.
Power of attorney is in my favor. Their case was power of attorney is forged.
Okay.
I was the power of attorney holder. Well, in the aforesaid backdrop, my lord, I have suggested the substantial question of law, my lord. I have also framed 2 additionals, my lord, if I may submit to your lordships. Okay. In the memo of appeal number 1, that is the issue of limitation. Of course, the prayer with regard to F, my lord, that has been held in my favor. So it will be only with respect to G, my lord. Challenge to a sale deed of 1996 made in the year 2013. And so far as the second point, my lord, I'll be urging the points which I have handed over to your lordship today, my lord.
Whether so many
No, my lord, only one. Only number 1, my lord, because two, three things, my lord, I had in mind, my lord, but those will not be because 202 will not come. The additional one which I have submitted to your lordships today, my lord, those will come. My respectful submission. Because the apex court has settled, my lord, the grant of a power of attorney is not giving an interest. In judgment in 2012, my lord.
Where is that?
That is Surya Lamps, my lord. I have not brought it, but it is clearly said, my lord. I can give the judgment. 2012?
there is, the Supreme Court has says that grant of a power of attorney does not mean creation of an interest. Of course, it will be different, my lord. Grant of power of attorney for sale, it will be different. Suppose, my lord, I give my land to a builder to make construction, give him a power of attorney, and he constructs something. Then I cannot cancel it without giving him a notice under 202. Similarly, suppose, my lord, I owe someone some money. I don't have the money. I give him a power of attorney saying that you sell this plot of land, and whatever money you give, you you can adjust from me. Then it will be creating an interest. But simply giving a power of attorney to sell, that the apex court has said that no, that will not amount to creating an interest. So 202 will not come. Although I had framed that substantial question of law while, my lord, drafting the appeal, my lord, but that will not come, my lord, is my respectful submission.
You do one thing, you submit the court, if possible.
That's Surya lamps, my lord. Yes, I'll do it.
With further order.
No.
Yes, Ahmed.
Yes, I have the caveat. I beg for by filing caveat. Here, you will also kindly see their written statement, my lord.
Caveat or only hard caveat. Yes.
Your written statement, you will also page 13, their written statement, and they file also counter claim. You will also kindly see 13. On relevant page 20, my lord. Five.
Yes.
The counterclaim is village friends of counter. Now here prayer is lots of kindly say. Those are their prayer. Now main prayer is, my lord, C. Grant partition issue separate patta sending trips and so, and dependent on one scheduled land of the counterclaim. Issue permanent. Now E. Declare that register give deed number so and so. Describe why counterclaim illegal in operator and void in law. Now next, my lord, issue precept to the sub-register of which Barbara to cancel and remove the register, give this so and so, so and so. Now the trial court has issue phase. This basically is the issue of the trial court, phase 36. Phase 36, madam. Whether the plaintiff number one and proper defendant have right title interest over the suit land, whether the plaintiff number one has right title sponsor, whether the main defendant are mere trespasser on B scheduled land, whether the plaintiff are entitled to khas position. Now, my lord, whether the G, important, my lord, whether the defendant number one and two have joint right, title, and interest position of the scheduled A land of the counterclaim, whether defendant are entitled for any relief claimed for. Now, let's look at see. Learned Munship trial court has decreed the suit and dismissed the counterclaim, my lord. Number one, dismiss the counterclaim, but they did not challenge the dismissal of the counterclaim. They did not file any appeal against that counterclaim, my lord. They challenged the decree where it is held that the gift deed is valid, inoperative, and the deed executed by the attorney holder in favor of the defendant number one and two is invalid because it has been executed after the execution of the gift deed. So now in second appeal, they cannot claim without challenging the counterclaim decision rendered by the trial court in counterclaim, my lord. They cannot. They should have filed two appeal, separate appeal. I will place those judgment also. There is judgment. Now their claim has gone because suppose your lordship pass this order.
Oh, why they cannot challenge the decree?
My lord.
Why they cannot challenge the decree?
No, they claim, but their claim is to be stabilized. Suppose in second level I lost the appeal. Then what about the finding on the counterclaim, my lord? Their counterclaim is only based on declare the gift deed as illegal. That counterclaim is dismissed. then what will happen, my lord? Now, if counterclaim is dismissed, their claim is dismissed, they have not made any challenge. And because of entitled suit, decree has been passed in my favor, holding that the gift deed executed by the attorney holder in favor of the defendants is illegal. First, it is there, my lord. So they cannot, without challenging even here also they did not make any challenge for dismissal of the counterclaim.
Where is that,
My lord,
where is that decision?
I will place, my lord. Today I will place, my lord. There is a decision in the Honorable Supreme Court and as well as Sikkim High Court, my lord. I will place.
When?
If they fake, tomorrow fakes, I will.
Now you produce. It's not available.
Available today is not available, but I can remember the judgment.
Let him
They
also
should have
go through
filed,
the decision.
my lord.
Let him also go
Yes,
through
yes,
the
yes. Number, yes. Tomorrow I will place it, my lord. The other part I can proceed, my
Then
lord.
let us adjourn the matter.
Yes. Tomorrow or day after tomorrow, my lord.
Let it be tomorrow, my lord.
Tomorrow.
I'm not keeping very good health, my lord. I'm having pain. Tomorrow I'll be coming to the court. Let it be
Tomorrow, my lord. Tomorrow.
It is not
I have no.
inconvenient for your lordships.
At 2, it may be taken up tomorrow as a fixed at 2, my lord.
It's a backup. Yeah, that's right. 31st.
Oh, there is an IA, item number 62. my lord. That may also be listed again. Tomorrow. Item 62.
Prove that I.
No, let it, that the I also come tomorrow. It is like item 62. That is what I was submitting.
I have for stay. I have for stay.
Review petition 9 of 2025.
Let me hear. No, this review petition we have filed basically on the ground that by the order passed by your lordship, relying on that stamp from the chairman judgment, that even if the appeal was dismissed on the ground that delay was not condoned, against that appeal lies not revision. That order is at page 185, man. I'll read my just 2 paragraphs, man.
Pardon?
I'll read 2 paragraphs, man, to drive home the point. Page 185, that you kindly see. Paragraph 3, man. 185. It is to be noted here that while impugned order dated 24/4/2025, the learned First Appellate Court had dismissed the application filed under Section 5 of the Limitation Act for condonation of delay of 872 days in preferring an appeal against the impugned KBAR decision dated 28/4/2022, passed against the present petition by the village authority of Incheon, Upper Siang District. Then next paragraph is also important. At the time of hearing, Mr. Pamel and counsel for the petitioners, while addressing this court on issue of maintainability of this civil division petition, submits that this civil division petition
The petitioners herein had preferred an appeal, being civil appeal number so before the learned first appellate court, along with one IA number so for the continuation of delay of 872 days in preferring the said appeal, but the learned first appellate court, after hearing learned counsel for both the parties, had dismissed the petition on the ground that no sufficient cause has been shown for continuation of above mentioned delay in filing the appeal against the impugned KBAR decision dated 28/4/2022, passed against them by the village authority of Incheon, Apache district. Now, paragraph 4.2, Roshul kindly see. Mr. Parme further submits that dispute between the petitioners and respondents relates to a land, and the village authority had decided the same by the original KBAR decision dated 16/10/2021 in favor of the petitioner. Thereafter, the respondents, lapse of more than 172 days, filed an appeal before the president of Gaungura Association, Incheon, Upper Singh district, and the said association, despite objection of the petitioners, passed the KBAR decision on 28/4/2022. Thereafter, against the said order of the appellate forum, the second appeal, being civil appeal number 30 of 2024, was preferred before the learned civil judge, and that against the order of the learned civil judge, third appeal is not maintainable, and therefore this civil division petition is being preferred. And in this case, what has happened actually, the appeal which was dismissed, against which the revision petition was filed, was actually second appeal, not the first appeal. In fact, my lord, will kindly see, the KBAR decision was taken on 16/10/2021. And one act possibly was not brought to the notice of this honorable court. The 1945 regulation was amended, and the Arunachal Pradesh Civil Courts Act 2021 was also amended. And after section 15, my lord, which provides for appeal, subsection 4 was inserted, which provides that against a KBAR decision, appeal lies to the court of Gaungura. That is the first appeal. Interterritorial British Council or Gaungura, by whatever name it is called. That is the first appeal. Against that, a decision appeal was filed before the civil judge. That was the second appeal. Then that was dismissed for not condoning the delay. Against that, the revision petition was filed. Now, my lord, in place of this revision, if appeal is to be filed, it will be a third appeal, my lord. Third appeal will not be maintainable. Possibly the amendment which was there already when this order was passed, page 175, Lord, just have a look at page 175. I'll show, my lord. Page 171 is the first act of Arunachal Pradesh Civil Courts Act 2021, which came into force on the date of publication in the official gazette on 12th of April 2021, page 171. Man. Page 171. Man. It's done. Now, page 173, Lord, will kindly see. At the bottom, section 15. Appeals, etc. Appeals from the decree or order passed by a court of district judge and courts of an additional district judge in original suits and proceedings of civil nature shall, when such appeals are allowed by law, lie to the High Court. That means from district judge it will come to High Court. Then subsection 2, appeals from the decrees and orders passed by the Court of Civil Judge Senior Division in original suits and proceedings of civil nature shall, when such appeals are allowed by law, lie to the court of the district judge of that district or in the court of additional district judge where such court exists, or the High Court as the case may be. Then, my lord, subsection 3. Appeals from the decree or order passed by the Court of Civil Judge Junior Division in original suits or proceedings of a civil nature shall, when such appeals are allowed by law, to the Court of Civil Judge Senior Division of the district. So these were the three sections, my lord, under which appeals were provided. Now, if we no, my lord, second provision. No? My lord, the second proviso at page 174. I'm sorry, my lord, I couldn't point out. Provided further that from the date of commencement of this act, in case an appeal is preferred against the judgment of customary court in the court of district judge or in the court of additional district judge, as the case may be, the court of district judge or the court of additional district judge may dispose of the same or proceed with the case de novo. But this act, when it was enacted and gazette notification was made on 12th of April 2021, it provided that against the order passed by a customary court, appeal will straightway lie to the district judge or the high court, depending on the valuation of the subject matter. And then the now subsection 1 and subsection 2 says, from an original order passed either by the civil judge junior division or by the civil judge senior division, only one appeal will lie, because appeal is provided only against a decree passed in exercise of original jurisdiction. This was the provision originally, my lord. Now it was amended, which your lordship will find at page 177, my lord. Subsection 4 was inserted. This provision was possibly not pointed out to your lordship, my lord. Page 177. This is the amendment of Civil Courts Act 2021. The Gazette notification came on 14th of November 2022. Lordship will kindly turn to the next page, page 178, my lord. Third paragraph, Roman 3. After the fourth proviso to subsection 3 of section 15, the following subsection shall be inserted. An appeal from the village authority, if agreed to by the parties, shall lie before the inter-village territorial customary court or apex customary court, by whatever name called, which shall settle the case as per the local traditional customary laws under the provisions of the section 40 of the Assam Frontier Administration of Justice Regulation 1945. This is the first appeal against the Keba decision, again before which is again a customary court, my lord. Then Lord will kindly see the first proviso. Provided that an appeal against the order of the inter-village territorial court or apex customary court shall lie before the courts of civil judge junior division, the courts of civil judge senior division, the courts of additional district judge or the courts of district judge, as the case may be, as per their territorial and pecuniary jurisdiction. Now what happens against the village authorities court? This is the first appeal under subsection 4, my lord, after this amendment. Proviso says there will be a second appeal also. Am I clear to Lord? Against the village court, earlier under the original act of 2021, Civil Courts Act of Arunachal, my lord, there was only one appeal, an appeal against an order or decree passed by a court in exercise of its original jurisdiction. Now, by inserting subsection 4 after section 15, my lord, for the first time, a provision has been made that against a customary court, that is the Keba decision, my lord, an appeal will lie before inter-village territorial customary court or apex customary court, by whatever name it is called, and it will be disposed of in terms of the provisions of section 40 of the 1945 regulation. The proviso, first proviso under section 4, my lord, the proviso to section 4 says there will be a second appeal, provided that an appeal against the order of the inter-village territorial court or apex customary court shall lie before the courts of civil judge junior division, courts of civil judge senior division, courts of additional district judge, or the courts of district, as the case may be, as per their territorial and pecuniary jurisdiction. Meaning thereby, my lord, Keba decision will be the first division original jurisdiction. Against that, appeal will lie to the inter-village territorial council. Against that, a second appeal will lie before the civil judge junior division, senior division, district judge, as the case may be. So two appeals are now provided. Now, after this amendment, my lord, 45 regulation was also amended, which your lordship will find on the next page, my lord, page 179.
Sir, sir, notice that there to be included.
My lord?
Notice.
My lord, yes. At this next notice.
Notice.
Yes.
With here.
My lord.
Third, sir.
Oh, number.
Oh, six.
Number 2.
This application got it. And order 47 to one of the code of for the order dated 5 or in here in our order 5 will not it for the by ATM on it but like this for the record will be required, right?
My lord.
The record
Record, my lord, what has happened is after your lordship passed that order holding that appeal will lie, the petitioner has already preferred an appeal, and that appeal has been numbered as RSA 4 of 2025. What I'm saying is, my lord, although I have prayed for an interim order of stay of the order passed by your lordship, at this stage, my lord, only that the records of RSA 4 of 2025 may be tagged with this, so that next time when it comes, both the matters can be disposed of, taken up together.
it's about council product that the respondent hearing
Fine.
have filed an appeal. Regular second appeal being RSA number
4 of 2025.
4 of 2025. And this matter may be taken with the effort regular second. Suppose we hear both the matter.
We may be given liberty to serve the notice to the council of the others. In addition to the normal step.
Both the council for the allowed was service of not response.
Item is.
After something.
Well, yeah, but.
Next.
Item 15.
This is a regular second appeal. Improving judgment is page 64, madam. It is 64 the improvement. But there are several litigations were running between the parties, madam, since 1967, madam. From 67 onwards, madam, the litigations were running by the parties, and now come to an end by this appeal, madam. What is the, madam, the respondent herein, madam, they filed an appeal, they filed a statute suit being 19 of 2000.
But Mr. Doctor, what is your substance?
Malad, we have annexed, but now, Malad, some sort of.
No, is it not part of the memo?
Yes. Malad, there is a there, Malad, we have annexed. We have annexed there, Malad. But not before the certificate, that is the problem, Malad. Not before the certificate, it was after.
File amended memo.
Yes, Malad.
All the cases it directed the party to prepare the memo that is as per subsection 3, section 100.
Yes, Malad. Earlier one done, Malad.
You have done.
I remember, Malad. I remember, Malad.
But why you have not done this?
But it was filed in 2019, Malad.
2019.
19, Malad. Earlier it was.
Why it was not put up for long period? Delay was not confirmed.
Delay was not condoned, my lord. The parties are died, substitution, everything, my lord. That is why it is delayed. There are so many.
But Mr. T does furnish the appellant. So how people get
Not for all the respondents, my lord. 34789.
Hawko, respondent number 347, 8 and
8
9.
9.
8, 9.
10 3 to 10 9. 10 3 to 10 9.
10, 3 to 10, 9. Okay. List of Mr. After 1 week, it's a done.
Tomorrow will file, my lord. Tomorrow will file, my lord. And my lord, there is a execution proceedings, my lord. It is fixed on 10, my lord. We have filed an additional affidavit bringing this order of the execution court, my lord. So if lordship not interfered, my lord, the execution will be done and our entire matter will be impacted. So we will file by tomorrow, my lord.
Let it be on Friday.
Of like, we can.
List of by day after are done by the incorporating the suggested substantial question of law in the memo of this recording.
My lord, kindly allow us 2 weeks time or it is up to you, my lord.
No,
I'm saying.
otherwise we will dismiss the appeal.
Senior says, my lord, it is up to court, my lord.
Yes, what is your submission?
My lord, last order, as per last order, my lord, they lied before the court that the amount has been already disbursed and it is coming from Calcutta, so 2 weeks time may be. Accordingly, lordship has granted 2 weeks time. My lord, as per order, my lord, page 10, kindly see paragraph 2. On hearing both the learned counsel for the parties, page number 10 of the IA, my lord.
কপি দিয়া নাই তুমি ন তো তোমাৰ আইয়ে কপি নাই মোৰ
কপি নোহোৱাকে ইমান দিন কেনেকে কৰে
নাই ইয়াত
আপুনি মিছপ্লেচ কৰিছে আগতে আপোনাৰ এপিয়াৰ হৈছেতো আজি সেইটো পেজ 10 লৰ্ড married para 2 মানে on hearing both the learned counsel for the parties, this court finds it fit to allow the stay of the operation of the judgment and order dated so passed by MSCT Darong at Mongoldoy in so subject to the deposit of 50% of the awarded amount by applicant within 4 weeks. Thereafter, my lord, assurance after assurance, my lord, operation of that award is state subject to payment of yes, they have failed, my lord. Failed to comply of this court order in spite of repeated assurance they have given before this court. My lord, I'll pray that if they are not interested to proceed with the appeal, and more particularly in the morning, my lord, she submitted that they are willing to deposit the entire amount. So necessity of this appeal in keeping it pending is not required, my lord.
My lord,
So
is paying the cover.
my humble submission is either close the appeal recording her submission, or my lord, as they have failed to deposit the 50%, my lord, the stay order may be vacated, granting liberty to the respondent to file execution proceeding in this case. First prayer to
Take the heart inside.
M. Aliman.
M. Ali, heart and tell us.
My lord, on hearing both the learned counsel for the parties, this court finds it fit to allow the stay of the operation of the judgment and order dated so and so passed by MSCT Darong at Mongoldoy in so and so subject to the deposit of 50% of the awarded amount by applicant within 4 weeks. Thereafter, my lord, assurance after assurance, my lord,
disposal of the order dated 25/6/2025 executed time. 5 was granted the appellate of the order by awarded amount in view of the order passed by on 14/9/20. It also appears from the order dated 14 that direction given to the appellant to deposit 50% of the awarded amount to the legislative court within 4 weeks. But the 14/9/2022, more than about 3 years elapsed until then, the appellant hearing has not deposited 50% of the awarded amount to the legislative court. They have been, the counsel for the appellant have been taking time on several occasions. They also prayer is being made for granting another 2 weeks time to deposit the entire amount before the date. The pair is allowed subject to payment of cost of rupees 10,000, which shall be deposited before the next next date. And in the event of failing to deposit the entire amount before the registry of this court after 2 weeks, then the interim order dated 14/9/2022 shall be the stand recall. Then order the court and liberty will be granted to the respondent herein. You are for the respondent to initiate the execution process for realizing the awarded amount.
And pendency of this appeal may not be a bar to decide the execution case, my lord. That may be offered. Sometimes, my lord, sometimes, my lord, when the appeal lies before the High Court, my lord, they wait for the decision.
Already granted if regarding
Yes.
well, the execution. So this is the method on execution.
Bless
So maybe you go for respondent.
Yes, my lord.
They also the appellant is
Earlier occasion also absent.
what to do?
Actually, my lord, this proceeding, I think there is an interim order. Because of the interim order, entire process has been stalled. Forward has been granted. I think
Interim order when it was passed.
at the time of admission of the appeal, I think.
No, there is no stay order.
Yes. No.
Is
Okay.
there any IA?
I am not. I got the appeal copy, my lord.
There is no stay order apparent.
So, my lord, last of it, my lord.
None appeals for the appellant on how about the Ahmed Garden for the present.
All the respondents.
For respondent number, all the respondents. All the it appears that on yes, that is 27, 2025. 12/12/2018 and 28/9/2018. Also, the appellant remain absent. In view of above, this appeal stands dismissed for non-proceeding. This is a different record. Trial court.
Hello.
Court.
May I please, Your Lordship? In this case, Your Lordship, as per High Court's order dated 18/6/24, passed in Your Lordship, IS 178/18, 1718, the appellant has submitted a representation before the regional manager in a railway. I have received the copy. I have to file affidavit in this regard, Your Lordship. Already affidavit ready, but due to illness of the opponent, it is time I am to file. After 1 week, Your Lordship.
So you are here?
Yes, Your Lord. I am for respondent number 1.
Or side the or apply for the respondent number. So it's the first that granted one time to file affidavit.
Affidavit ready.
Additional affidavit. Paid in the court. This is the matter of our bargain.
Much.
God bless you. May I please, Your Lordship? Lordship, service is complete, Lordship. Yes, Lordship.
That is for
Admission,
it is already admitted for
appeal is admitted, Lordship.
hearing.
I is there, Lordship.
I for
I for stay is there, Lordship. I have filed a petition under Order 39, Rule 1 and 2, Lordship. They filed by affidavit in reply, Lordship. Weeks maybe, Lordship granted for filing affidavit.
in FAO to take the part is that
P. Sharma.
started for that
A. Hussain.
started on the structure that the part healthcare will be required.
No, Lordship.
Not
No.
then that's the better hearing. Putting it for after week I take hard so hard the learned for the response substance opposite party allow quick time to file objection in this interlocutory application. This is the matter of purpose.
Date me. If possible.
Ticketed.
God bless.
And please, office note dated 4/8/25 says that as regards respondent number 2, service is not completed.
The Bhakti
One is the caveat. And
so you want to take test.
Hello?
You want to take test system.
No, await for service report.
Survey.
Service report.
Or the either it is the Bhakti. It's the matter after 2 weeks, everything started. The numbers.
Interim order to continue, my lord. 12 months. I'm deeply aware.
Much obliged.
May I please rise, sir? There's a restoration petition, Your Lordship. One miss case is there.
Pardon?
One miss case for restoration of RSC, Your Lord.
This I is for what?
I is there for condemnation delay, Your Lord.
You go for respondent number,
I am for the respondent number 1 and 2.
third is complete.
Yes, sir.
Delay of
Delay of 296 days, Your Lord.
any objection?
No, my lord, I have no objection, but it is the appeal of 2010, my lord. So, hearing may be. It may
Your Lordship, the petitioner number, appellant number 2 has expired, Your Lordship, and that we have to substitute his name. We have already filed substitution petition, but there is an abatement petition also.
But not the delay has to be controlled.
Yes, Your Lord.
But here also he is required to be substituted.
Yes, Your Lord.
By legal there.
Yes, my lord.
In this application of
Yes, Your Lord.
third is the
Applicant's name is in there in condemnation application, my lord. The respondent number, applicant number 2. That person name is there.
he suffered by.
Yes, my lord.
Therefore, he will take a step here.
Now, arrest in application in restoration in condonation application, my lord. Applicant's name is there, who is as per his stated Muninder Bhumike was already
Yes.
expired.
Expired, Your Lord.
And
We want to substitute
in
his name.
as applicants, his name is there, my lord. He was a dead person, my lord.
Subsequently, he died for it.
Yes, Your Lord. Subsequently, he died.
Third is that
S. Decker.
yes, Decca.
Yes, Your Lord.
Third and applicant. Decca that applicant for 2. Bhumike suffered by. And there is one of completing the legal hair. Completing 8 legal hairs with the pick. And you will file an application.
Application already filed, Your Lord.
Yeah, already filed.
Yes, Your Lord.
When
While filing this IA as well as miss case, Your Lord.
Then that time he has expired.
so here also you have to file the application. In this application.
Your Lordship, I have already filed one IA, Your Lordship, 113 of 2025, Your Lordship.
When he died?
Long back.
Long back.
So there is a delay, Your Lordship. Abatement petition also filed, Your Lord. There is a delay of, Your Lordship.
Then why you are making here applicants by that person, application by that person, why you have mentioned his name? Applicants as applicants?
No, it was in the RSA. That
No, applicant.
no.
Applicant. I'm not
Let-
saying about appellant, I am saying about applicants. Application by that person.
So there is a delay in filing substitution application.
Yes, Your Lordship.
So
What
delay
happened, Your Lordship, the counsel who was looking after this case, he expired in 2017. So the applicant, he was not aware of his death, Your Lordship, because he is.
that's all right, but it is application to condonation of delay.
Yes, Your Lordship.
The name of that person is there.
Yes, sir.
Is it not necessary to deplete the legal hairs of this?
Yes, Your Lordship. Necessary, Your Lordship. Now, since the RSA has been dismissed for default, so we have to file this condemnation petition because there was a delay while filing the miss case. So So without restoring the RSA, we cannot substitute the legal here.
Mentioning of his name in the mentioning of his name as applicants, application by death person. That
Could you follow?
Yes.
So in this application also you have little legal hair
Yes.
of this person.
Yes.
as a
Thereafter we price for granting 1 week time you file it.
Yes.
Where is accordingly allowed. That's 1 week. Thereafter we will allow other petition.
Yes.
right, please, your lordship, this including this I is for allowing the applicant. I have filed the guardianship appeal, my lord, and in the lower court order, there was lower court has allowed me to continue to visit my child as per the relevant direction passed earlier in the present case. But the respondent is not allowing my child to visit, my lord. That's why I have filed this application, my lord. Other side is name has been.
What is this? FAO is pending.
FO is admitted, lower court record has come, my lord. Another side is entered appearance, my lord.
When that matter is listed.
Note appeal was admitted on 28/10/2024.
Next day.
Next date. No, next date.
Not given.
Next, no, hearing date is not given, my lord. LCR has already come. Hearing is.
We have to it's notice.
Other side has entered appearance, but nobody is there.
Third, that's the third application. This application referred for direct the opposite party of the application. They are minors on as per order dated 15. And once the card is empty, miss with the ticket D number 05 of the this notice returnable in 2 weeks or 4 weeks.
2 weeks. I will take steps tomorrow.
The be taken by registered or registered for and within work days from there. Should we direct to this matter along FAO?
Your lordship may fix a date.
Ms. Roy submits that connected FAO number 74 of 2024 has already been admitted by the court and the record has also. And this matter may be taken the FAO number 74 of the court. Accordingly, it's provided that this is the matter after 2 weeks and take this along with FAO.
Your lordship may fix a date.
What a good point. Lordship, after filing objection petition, he has made a prayer for withdrawal of the amount deposited. After filing objection, Lordship.
Why?
This policy was not a motor insurance policy at all. That was my ground of. It was a plant and machinery policy issued to a contractor. The person who died was the helper of the excavator. This this policy carries a third party limit of 2 lakhs only. That's defined in the policy. That too, he has to be a third party, someone who gets crushed by the excavator, etc. That's not a third party policy. Name is contractor's plant and equipment policy.
not issued under Indian Motor Tariff Act or under motor policy. That is my ground of appeal. That accordingly evidence was laid before the tribunal. So I have to file an objection notice that is necessary. I'll take that within 2 weeks. I'll file the objection.
The applicant is application preferred by the for allowing to withdraw property amount 7,81,350 deposited by the applicant. Mr. Goswami learned to put the party that he may be granted time to file objection. There is according to law.
Obliged.
Obliged.
Yes, Your Lordship. Your Lordship, I ask for delay continuation, Your Lordship. There's a delay of 1038, Your Lordship. for filing. 1038 days delay, Your Lordship. But from the there's only 72 days from the knowledge. Days of knowledge, Your Lordship.
72 days.
Your Lordship.
Let notice go it is
Yes, Your Lordship. Notice may be still.
after 4 weeks.
Obliged, Your Lordship.
Please, Lordship, in item number 37, being respondent, I have filed objection in affidavit in delay condon petition yesterday. That it is not taken with accord. So, item will come out from
Item number 37.
37. Yeah.
Art is that
As Gautam, Your Lordship.
learned counsel for the applicant. Filed one objection.
Objection.
But the same nothing in place for next Monday.
Next Monday.
There is according to
Rest may call for affidavit. I have already filed objection, so it may be taken with record.
let's take the affidavit along the record.
Obliged, Your Lordship.
Yes. I have for delay connection, Lordship. Notice may be issued, Lordship.
Okay.
1068 days.
Okay. After 4 weeks.
Your Lordship, revision petition earlier it may be continued. Revision petition, intermediate may be continued.
Delay condonation for what purpose?
Substitute petition. Legal hair respondent 5.
Art. Place the matter after 2 weeks. After 2 weeks, trade order for certain shall continue. Therefore,
May I please, Your Lordship? We have filed 3 IS for condonation, setting aside abatement, and substitution, Lordship. A delays of 37 days.
delay, delays,
37 days, Lordship.
37 days.
Okay, we have no objection.
No objection.
No.
Art, Hazurika.
Yes.
Learned.
R called.
Are court application. Five. Date. In subscripting. Detail layers of the this is applicant number 2. Alternate option for the respondent opposite party applicant is pedagogic. With the explanation of worded in paragraph number where you have explained it. Paragraph number 3.
Yes, Lordship.
In paragraph 40 of the application, 40 of the unit, the delay of 37 days is sufficiently explained. In terms of this by and in view of the order passed in this IA, the complaint for the appellant in RSA number 63 of 2005 amended for the 1 week from today.
Obliged.
Before I begin in the case, I must tell your lordship one thing. These applications for impleading of parties were filed on behalf of the British appellant Milan for the death of the sole defendant. In 75, first appeal, 75 or 25, I filed application for substitution of the years, Milan, of the year on 39/24. And from that date, Milan, this is the first time the matter is coming to the court. Only that at the mention of my learned junior. It is a very bad precedent for the High Court. Milan. And in 76 also, along with the substitution, I have filed an application for injunction also. I prefer in these cases, Milan, I have filed application for substitution. Then since it was barred by limited abated, application for setting aside abatement, and also for condemnation of delay.
51 days.
Delay of 51 days. 51. 51.
But here you are appearing for the response.
Appealant.
Any objection?
We don't have any objection because it was filed in 24 itself. Regarding the condemnation of delay, we have no.
Emerald.
Under order 24.
My lord.
Group O of the Code of Civil Procedure, it will take 5 part. Condemnation of delay of 53 days in deferred.
53 days.
5. Oh, condemnation of delay in deferring an application under order 24 of the Code of So, this paragraph number 5
My lord.
is the explanation.
My lord. Somehow, Milord, I do not know. We submitted all the papers for the clerk, Milord, the clerk, and as from my record, I have noted that it was filed on 24/6/24. But that papers were not found in the court records, so I have to file another petition, Milord, explaining the delay.
Okay, the delay in filing the application for substitution here was due to the lapses and error committed by the adjacent client.
Fine.
And then there is no and the same bona fide one, that's the same that they do Mr. Bhatia learned that he has no objection.
No.
In concerning the delay of it. We are taking to the submission of learned counsel to both the parties and also to the experience for the type of the application. This court is of the view that the delay of 53 days in filing the application is the accident, that therefore the things terms of this IAS that is put up. And where is the substitution petition? I number?
That is at
So 3686.
3686, no? 886.
368.
3686, no? I'll give you the names also. Legal years, paragraph 2.
Particular detail of the part that under order but the part by the or aside abatement that bringing the legal hairs on date of the defendant respondent. This one RSA number in FAO number 25 of the Mr. Bakir, what is your submission here?
Rasif,
No objection.
no objection. Let the legend has been completed.
Mr. Bakir, current opposite parts of yes, okay. Mr. Tobia, current for the applicant subset. Sole dependent Pradeep Kumar Jain suffered demise on 10/5/2024, leaving behind four legal heirs, namely Sandra Devi Jain,
Naila.
of Jain, Binti Kumar
Binti
Jain,
Jain.
and Pooja Jain.
Binti Kumar Jain and Pooja Jain.
And said the legal heirs are required to be implemented in place of the sole respondent, sole dependent, sole defendant.
Pradeep Kumar Jain.
Pradeep Kumar. Erratic pardon of vocal party. Then of course the fact or the subject allowed. The name of four legal heirs as mentioned here in above being treated as legal heir of two dependent named Pradeep Kumar. In view of the in terms of this IAS is full of in the order passed by now the council to the appellant that file amended postage in the FAO number 75.
Malan.
This after doing
76 also. Three seven eight five is the
76 also take matter.
same matter.
Okay. So same order is to be passed there?
Yes, Milo. Party are same. They are also application for substitution, then setting aside amendment and for delay.
Okay.
And here I filed another where I submit Milot. I filed an application for injunction also, that may be listed after 2 weeks or 1 week. That also I filed earlier.
What is the number?
1125.
One of
Yes, 1125.
Mr. Bakir, you want to file an objection here?
That's it, yes.
Or you have filed?
We intend to file it.
You
My lord, I object to that, my lord, because it was filed in 9/24.
Earlier, on 12/10/2023. Injunction petition.
Injunction for no. No. Yes, sir, we intend. 3/24. More than a year has passed by. So no time should be given. That will be fixed for here.
File in the meantime, we may file that.
Okay.
Only for them it is delayed.
This is FAO
of 23.
And in the meantime, the Bakir may file his objection if so.
Even right. Lots is shaking in this mill. For this 76. Minor. Obliged. What's obliged? Mark.
Please, your lordship. Lordship, this IA is for vacating the stay order. Lordship, in this case, the accident took place in the year 2015. And I am the widowed mother of the deceased. Your lordship, so far my submission.
They have not deposited the amount.
No, the stay has been granted till disposal of the appeal without any deposit or security. Whereas your lordship, there are.
No, it's what is the pair in this application?
Vacate the stay order and direct the insurance company to deposit 50%.
No, without vacating the stay order, we can direct them to deposit.
No, lordship, we want to file our objection to this. So some time may be granted in this IA, lordship.
Why?
In this IA. Because the ground we have challenged is fraud. And the date of admission, lordship, the honorable court gone for our grounds, and after that, lordship.
Your lordship, I want to give this
sometime
order of this honorable court.
Heard Mr. Montauk Cardiac for the applicant. This applicant
The court has made this observation.
for vacation of the order. Stay order dated 12/8/2020 passed with IA civil number where this order was passed.
No, your lordship, in another case, similar prayer was made and the court has observed on the date when it was fixed for hearing, they remain absent. Your lordship, I have two judgments of Supreme Court which says that in case of money decree, it is a condition precedent. For grant of stay, they have to either deposit or deposit money or security in case of money decree. I have two judgments of Supreme Court, your lordship.
That's why to counter the arguments of my learned friend, lordship, one small opportunity may be given to file our objection.
Normal burden for the opposite part that one week time to file objection. That is out.
Your lordship, since the accident took place in 2015, your lordship may be pleased to highly obliged.
But
Your
why
lordship.
you have not come earlier?
Actually, there was some miscommunication. between the party and
Okay. Yeah, next.
highly obliged.
Please be my lord. Lordship, this is a prayer for release of the amount deposited by the insurance company, 50% along with the interest, Lordship.
Yes, Madam, any objection?
No, Lordship.
No objection.
No, Lord. Lordship, may kindly pay with the order, Lordship.
Order.
Order that is passed, Lordship passed by this honorable court to file granting stay. Lord.
Yes.
Regarding apportionment only, Lordship, we have filed the appeal against two insurance company. So this is my apportionment. That's why I have no objection.
This is not your.
My apportionment is 50%, Lordship. The
Okay.
other, yes,
You have deposited the
50%. Yes,
entire amount.
50%. My 50%, Lordship. And the other insurance company also asked to deposit 50%, and another appeal has been filed for that, Lordship.
They have deposited Lordship 2,77,897. So that may kindly be released.
But sir, Agorka, Garnet, Epic, and so Epic, for allowing withdraw 50% of the awarded amount. That is 1,897.
Itu kan appeal no number to দিব লাগিব।
Person order court dated 3/4/8/8 number 354 of 2018. Corresponding to MSC case number 806.
MSC appeal number 816.
Chaudhary Samit said he has no objection. Let us take the party.
Ini koi
This
Lordship, another prayer is Lordship. The two appeals has been filed by the two insurance companies.
I have also filed an appeal under same.
So that both the appeals should be taken together, Lord. There is another appeal number is 367/18. It is not here today.
These are tagged and they can be disposed of.
dispose of, Lordship. On the same ground, Lordship.
Art and Agora Garnet response. The Agora submits the same judgment and award another
Bearing number 367/18. 367/18 by the New India Assurance Company.
18
Yes, sir.
By New India Assurance Company.
by the New India
Assurance Company.
and in the interest of justice, both the measures are hard to be done. And according.
Yep.
Come for order. Come for order.
Both the
Lordship, we put both the appeals.
8/6/2018
MSC appeal number 816.
367/18.
367 of 2018.
Right?
After 2 weeks,
Lordship, then it can be put up in the local, we can say 13/9.
on the next day,
Okay,
when the next to catalog is
13/9, 13 September.
30 September.
Yes.
After 2 weeks,
Okay, we'll pray.
We'll pass.
We'll pray.
Must oblige, Lordship.
So many.